Any mention?
Lord, I beg to mention unlisted matter for tomorrow, my lord. There's some urgency in the matter, my lord.
This matter?
Fresh matter, my lord.
What's the matter about?
Lord, this relates to the Mokhar Presbyterian Church. Now the district administration, the DC is interfering in the...
Look, this matter? This is nobody.
No, my lord. The DC has interfered in the religious functions of the church, my lord. That is the issue. It's not on the management, just on the interference.
Not
tomorrow, my lord.
Yeah, that is not not very.
I'll point out a few things, my lord.
Interfere.
Not on management, my lord. Absolutely not, my lord. Deeply personal.
Yeah, Mr. Pascal.
Leave to mention a matter for filing and listing tomorrow, Your Lordship.
Which matter is this?
This relates to the tender matter, Your Lordship, of GHADC, Your Lordship. Because they are in the process of issuing fresh notice for tender, Your Lordship, on Friday.
For what tender for?
Your Lordship, this here the tender was floated and I had participated as a contractor.
For what? For construction?
Construction, Your Lordship.
Okay.
Yes. Deeply obliged, Your Lordship.
I pray for listing unlisted motion transfer matter by the NIPCO. Under NIPCO trans policy, the employees who are about to retire within 2 years, posting will be given at the choice of their employees or nearest to the hometown. Here the petitioner is about to retire within 14 months only.
Where is he posted?
He has been posted to Guwahati.
Where is he posted?
He is posted in Shillong.
Is it against transfer policy? There are judges of this board.
Yes, Lordship Judge knows of that. To list it for the table.
Today?
Oh, my lord, we are filing. But
why?
He
the
put
order
up
for movement has come.
My lord, they did not issue release order, but they are forcing him to join, my lord. He put up the representation also, they are not disposing of his representation. We some copy to the other side also.
Okay, if you can do it within, let's see.
But, deep look.
Transfer, yes.
May I please, Your Lordship, I beg to mention item number 152, Your Lordship. The learned senior conducting counsel is in sanction leave, Your Lordship. Therefore, I humbly
NEPCO matter.
Yes, Your Lordship. So I humbly pray, Your Lordship, this matter be pleased to fix after 2 weeks.
Yes. Yes, Mr. Yubin.
2 weeks, the interim protection is there. So since they are seeking time, I have
no interim protection.
There was some.
You're seeking, if we remember rightly, after the last argument, you're seeking. It's a projected prayer you're making. So you didn't qualify to the new.
No.
Yes.
It's not like
you're seeking to impose your select list on the future recruitment also.
No. It's not like that, my lord. Because that's
1 week you'll prepare the matter.
2 weeks, my lord. Since
2 weeks.
2 weeks.
So it's not 2 weeks.
Much obliged.
Yes.
Please, Your Lordship, I beg to mention item number 145 on behalf of the Advocate General, Your Lordship.
On behalf of?
The Advocate General.
No objection.
You're appealing for the petitioner?
For the petitioner.
Yes.
Much obliged.
Please, Your Lordship. Your Lordship, I beg to make a mention of item number 151, Your Lordship. Lordship, in this matter, I'm praying for 2 weeks' time, Your Lordship.
What's the matter about?
This is tender matter, Your Lordship.
Tender matter?
Yes.
Yes.
No objection, Your Lordship.
No objection. Where's Dr. Mujika?
He has some personal difficulties,
Does
Your
come to
Lordship.
court today?
No, Your Lordship.
Yes.
Highly obliged, Lordship.
After?
2 weeks, Your Lordship. Obliged.
Yes.
Your Lordship, I beg to mention item 137.
Lordship, this is that section 11 petition, Lordship, which Lordship has already heard, that NK trading, Lordship.
After 2 weeks,
The
Your
limitation part?
Lordship.
137.
Yes, Your Lordship.
So what to do then?
Lordship, they are in difficulty.
If you've heard, we dispose it of. Why was it adjourned that day? Why was it?
Lordship, learned DSGI was supposed to come with instructions, Lordship. Because prima facie it was found that after the 7th bench order, Lordship, by the Honorable Supreme Court, that the scope of the referral court, Lordship, is limited.
It's only that it can
only that
tribunal to decide on daily also.
Lordship.
Yes. After?
1 week, Your Lordship.
Okay.
Hello.
Hi there, Raj. May I please, Your Lordship? Lordship, I beg to mention item 144, Lordship.
Item number?
144. I'm praying for 2 weeks' time, Lordship. No objection, Your Lordship.
Yes.
Obliged, Lordship. May I please, Your Lordship? Your Lordship, I beg to mention item number 146 to 149, Your Lordship, on behalf of Ms. T. Angie.
What are these matters?
Your Lordship, these are DCLP matters, Your Lordship.
This is for regularization, my lord.
Yes. You
I
no objection?
Lordship, no objection, my lord.
Yes.
Much obliged, Lordship.
May I please, Your Lordship? I beg to mention item number 143, Your Lordship. I'm for responding 5 to 8, Your Lordship.
Who's 5 to 8? Yeah, Darbash from
Yes, Lordship.
Why adjourning it?
Mr. Simcon is on leave.
You're with Mr. Sinkon?
Yes, Lordship.
Okay. Yes.
My lord, may I mention item 150,
How do you
my
present?
lord, 150. But if this matter can come up after 2 weeks, my lord. Personal difficulty.
Is a pension matter, MDC pension?
Yes, yes, my lord.
Yes.
We're a formal party, Your Lordship, yeah.
Where's Mr. Day? You inform them.
I'll inform them. my lord.
Oh yes, MS Lamare is here. Any objection? 150?
Mention 150. DC.
No, Your Lordship.
Yes.
Lord, item 136, my learned friend is there online to mention. He
136?
informed me.
May it please, Your Lordship, I beg to mention item number 136 with the consent of the other side.
Yes. For how long?
2 weeks.
Okay.
Deeply obliged.
May I please, Lordship, I beg to mention item number 141, Lordship.
All
141.
who's the other side?
I'm appearing for
No
the state, Your
objection.
Lordship. No objection.
Yes.
Much obliged, Lordship.
All matters.
Daily list item number 1.
Contempt matter. Where's adjourn last time?
We were supposed to take instructions, Lordship. However, Lordship, till date, Lordship, we have not been able to take
Then we
instructions.
close the contempt. We file a fresh.
Lordship may have it tomorrow, Lordship. I will tomorrow, Lordship.
On so and so. On 9/6/2026, adjourn was sought to allow the additional of the instructions. Tim S. Chanda also prays for further time of the instructions. As the contempt matter, it appears there is no urgency. List of the matter stands closed.
Lordship,
We need
let
to
it be
file a
tomorrow,
fresh-
Lordship. Lordship, I'm praying, Lordship.
You can't just keep it like that. You can't file a contempt just for filing sake.
Lordship,
Okay, list the matter up to 1 week under prayer with S. Chanda.
Lordship.
It comes tomorrow will be the same outcome. Yes.
Supplementary list item number 1.
Lordship,
What is this?
Lordship, this is the freezing matter, Lordship. Here, Lordship, what has happened is, Lordship, an FIR was filed, Lordship.
Yes. Yes.
This is that bonded warehouse matter, Lordship, where what has happened is an FIR was
Well, same matter we arrested in the airport and
Lordship,
brought to.
Lordship,
What
Lordship.
happened
Now, what has happened is, Lordship, there was an order from the court of the CGM for freezing of a particular account that was in respect of company in Rajasthan, Lordship. Now, after that, what has happened is, Lordship, the IO of the concerned police station, Lordship, issued a notice to the concerned bank for freezing of all my accounts, Lordship. So, on the basis of that, Lordship, all my personal accounts, Lordship, which is not the subject matter of this case, also has been all, Lordship, freezed, Lordship.
You've heard Ms. S. Chanda issue notice after 1 week. Where was appealing for the state? You served notice.
Lordship.
Though notice has been served and none appears on behalf of the state respondents.
I'll appear, Your Lordship.
Why is this happening? Why you have any instructions?
No, Your Lordship.
When was this matter filed?
Lordship,
Notice was received on 19. Today is the 20.
It was filed on last week Friday, Lordship.
Yes. So expectedly some instruction to be received. Issue notice. No, MSZ in authority is present on behalf of respondents number 124. No further notice on respondent. Notice issued to remaining respondents within 3 days. The petitioners agree with the freezing of his account, which he submits is without any authority, inasmuch as though there are orders from the CGM of Riboy district,
Lordship.
CGM of the Riboy district directing freezing of your accounts only.
No, Lordship. It was my father's account, Lordship.
Then we won't record that. We should notice this after 1 week for instructions.
Item number 2.
Hello.
Obliged, Your Lordship.
Yes.
Lordship, the corporation was supposed to come
Yes,
with.
where's Mr. Pandey? Yes, where's your instructions?
And my lords, I will share, my lords, a letter dated 17/6/2026. 17/6/2026. This is a letter, my lords, to the executive engineer with reference to the subject is, my lords, disconnection of JUD limited feeder. And with reference to the subject cited above, I am to inform you that as instructed by SLDC on 16th June 26, JUD Limited was disconnected at 18:25 hours without delay. So, my lords, on 16th June, this disconnection has already been effected. And my lords,
What are these other documents you're showing?
the other documents, my lords, may take note of a 26th May extension which was granted.
That's
my lords, must
anyway,
be
Mr.
page,
Chanda, you have taken instructions. You received this new cause of action now.
I'll take instruction. Have it.
Yes, today, Mr. S. Pandey, with so and so has submitted a letter, a communication dated 17/6/2026, which indicates that the connection, that the power to the industrial unit, operational unit, has been disconnected on 16/6/2026 at 6:25 p.m. Stop. Mr. S. Chanda on this development. Next line. Please allow to appear instructions. When you want it?
Tomorrow, Lordship.
Tomorrow. This is matter. Will
I am not happy after 1 week, my lords. Because
Yes,
I'm in
urgency, Lordship. So, Lordship may have it day after tomorrow, Lordship. Day after tomorrow, Lordship. Because
day after tomorrow,
they had the entire day yesterday.
Let's see. Day after
They had
tomorrow.
the
Put someone else here.
Hello.
All right.
You pay something, Mr. Chanda. Then that only be consideration.
Lordship, we have been paying, Lordship. Only difficult
You
things,
pay your
Lordship.
dues on after installments. You clear. You won't clear your dues today, or you make a representation.
Lordship.
It's just we not supposed to give advice, but if you want the matter to be resolved by the after, yes.
Daily list item number 2.
Please, Lordship.
May it please, Your Lordship. Your Lordship, I'm.
These are these SOP matters.
SOP matters, Lordship. SOP
Yes, Your
matters.
It's for hearing.
No, Lordship, it's for pleadings are yet to
Admission
complete.
given, Your Lordship.
Why please complete? Where?
In these matters,
No, but you file affidavits in all the matters.
in some of the matters,
Lordship.
Lordship, they had placed a chart
Where's
on
the
the
chart?
last occasion.
Yes.
Your Lordship, I pray that this matter may come up.
This is your chart, right? Subject textile.
Yes, this is placed by the state.
Then the one placed by you.
This is the one. This is the
You
chart.
make a chart.
No, we had compiled the chart earlier, Lordship. That is submitted.
Yes,
This is pertaining to filing of the
correct.
affidavits, Lordship. Lordship, I want to point out one submission from here, Lordship. So far as the paramedics is concerned, Lordship, can you come to page 2, serial number 3? Serial number 3, Your Lordship, health.
Yes.
Now the first one, Your Lordship, WPC 55725. 12 petitioners, BB Sina L Nongrang.
Yes.
Lordships, they are paramedics and they are bonded paramedics, Lordship. Now second also WPC 558
Archival did not
2025.
file affidavit.
No, they had filed here, Your Lordship.
They have not filed here in this.
Lordship, they had filed in
557.
557, they had filed.
Have you filed? No.
They had filed, Your Lordship, I
Your
have received.
Lordship, I'm praying that this matter may come
No, it's not
up
been
after
filed. You sure?
It's filed,
Let's
Lordship.
see the affidavit. Where's the 557? It's not been filed.
It's filed, Your Lordship.
Your Lordship, I'm praying that this matter may come up after a week. The council. After a week, Your Lordship. I'm a little handicapped today, Your Lordship. I don't have the brief with me.
Hey, please, Your Lordship. Your Lordship,
It's they have
Filed.
filed. Lordship, some submission because pursuant to the
What about this? Okay, come first to this number 2 GNM Health. In this 559 been filed.
559, Lordship. Lordship, what I want to submit is that, Lordship, pursuant to the cabinet decision, Lordship,
These people have been regularized.
no, Lordship, they have been taken steps that was supposed to be taken, Lordship. Now they have only notified.
To absorb them.
No, they have only notified for the staff nurse, Lordship. Now what's left is for the paramedics. Now, Your Lordship,
This BB Sinal, they are paramedics.
they are paramedics bonded, Lordship, and even number 2 also, Your Lordship, 558 2025.
Let's see that. Please ask them.
But in the affidavit, they have taken a different stand, Your Lordship, contrary to the
Have you
cabinet
filed a
decision.
rejoinder to this?
No, Your Lordship. That's why I want to point out, Lordship, what is the stand of the government, Lordship.
Since who's leading the matter? EG?
Yes, Your Lordship.
Because so far as bonded staff nurse and paramedics, Lordship, there's a cabinet decision for screening, Lordship.
That was brought notice of the court last time.
Lordship.
That the consideration for them to be absorbed shall be taken out from this.
Lordship. So for the staff nurse, they have done the scrutiny, Lordship. Now they're left out with paramedics.
How many staff nurses are involved? How many petitions are there?
Lordship, there are about 1, 2, 3, 4, 5, about 5 repetitions concerning the staff nurse and 2 concerning the paramedics. So in one of the paramedics, Lordship, they had filed a counter affidavit, Lordship, which is contrary to the. So we want to understand what is the stand of the government, Lordship. The cabinet decision says otherwise.
Maybe you take down MSZ inquiry today has sought some accommodation due to the absence of the Advocate General who was dealing the matter. Stop. However, Mr. ML Nongpur, the council petitioner, has drawn attention to this court to the affidavit filed in WPC number 557 of 2025 and submits that though it is public knowledge, that the petitioners, it's public knowledge that such similarly situated employees, with regard to such similarly employees such as staff nurses, steps on to absorb, recognize them. However, in the affidavit of the state, the same is not disclosed. He prays that the same be clarified before the matter is taken further. And the submissions of the learned counsel are noted. However, as the learned applicant is absent, this matter went. Yes.
2 weeks. 2 weeks.
After 2 weeks, Your Lordship.
After 2 weeks for further orders, rejoinders to the other applicant will be filed in the meanwhile.
Your Lordship, in item 114, I'm appearing for the MPSC, Your Lordship, respondent 6. I'm praying for some time, Your Lordship.
Only one matter appearing
Your Lordship, only one matter.
in WC 114.
WPC 3.
WC number
3 of 2026.
3 of 2026. September Paranlang. Prays for and allowed further 2 weeks' time to file affidavit. This together with the other matters.
With respect to petition 518 of 2025, we haven't received any affidavits.
They have not filed many of them, but she's not in a position to apprise the court. Just for yes.
Obliged, Your Lordship.
$117. $117.
May I please?
Yes, Mr. Roy.
My lord, the petitioners herein that they are the service provider, the agency is a service provider. My lord, he has been working with some of
Where's
the...
MS Yang is not here. Where's
For the state, I'm there, Your Lordship.
is there? Mr. Changreso?
Pleadings are complete, my lord.
Yes, you filed rejoinder. You want to be heard or you want to?
No, we have filed rejoinder, my lord.
You filed, I am for
We'll
5
put
and
it for
6.
hearing?
Yeah.
My lord, your lordship may fix it for hearing.
When do you want it? Yes, after 2 weeks.
Any time, my lord, your lordship.
Yes, parties submitted pleadings are complete according to the matter for hearing.
So the interim order to continue, my lord.
Interim order we need to continue until further orders.
Until further orders. Okay.
118.
Please, Your Lordship. Your Lordship, here the petitioner required to file a rejoinder.
Wait, please, Your Lordship. Your Lordship, I'm seeking for 2 more weeks' time to file the
How many times have you taken?
This will be the second time, Your Lordship.
What's your name?
Beelingdo.
Beelingdo. Beelingdo or Lingdo?
Lingdo.
Yes, I miss Beelingdo phase 1 out further. 2 weeks time to file the joinder. This thereafter is on so.
119.
Your Lordship.
My lord, I have sought instruction in this regard, my lord. All the documents which has been provided pursuant to the order which has been passed for filing of show cause, the inquiry report is not there, my lord. Even at the stage of the single bench when the order was passed, records were called for, my lord. There was no indication of the inquiry report, my lord. That's one thing. The other thing is, my lord, the area has not been paid till now. The court order is very clear, my lord.
He's not in station, Lordship. Lordship, I'm praying if this matter may be taken up sometime next week, Lordship.
So take up next week. Yes, Mr. What? Mr. Elkirim. Today has reiterated submission that the inquiry, although other documents have been received, the copy of inquiry report was not amongst the said documents. MS Emercham prays that the matter next week as the learned DSCI is not present today. Prays around this up to 1 week.
120.
Please, Lordship, here the government is neither supplying the copy of the report, nor they are filing the affidavit.
May I please, Your Lordship?
This is the VSC matter actually. The private respondent they have filed.
Mr. Sheikh.
He's out of station, Your Lordship.
All out of station. And how does court function?
So he's just paying for 2 weeks' time, Your Lordship, to file the affidavit.
On the last occasion, they have they have been asking time and again. There is numerous times which they have asked. At least they can.
How many times? Let's see.
More than 4 or 5 times.
We have the respondents.
On the last occasion, they have asked for two weeks because this is the VSC matter actually. There is a court order.
You only seen an inquiry report, correct?
No, they have not supplied. They said that they will file the affidavit. They have never. I have even asked.
For the court.
They have not filed the affidavit.
Take down. Though Mr. S.C. Sheikh, GF 123, had on 8/5/2026, which was recorded by this court, undertaken to file an inquiry report by way of affidavit. Stop. Today also the same is not yet on board. Stop. This is matter. Come tomorrow. This is matter on Monday. Monday the 29th.
Lordship.
Yes.
Much less, Lordship.
121.
You do not give undertaking to court and do not abide by it. Lucky this court is staff. Otherwise, such undertakings you give then.
Lordship. Yes.
Yes.
This matter, Your Lordship, the petitioner, the family member is admitted to the hospital, so he's not able to come. But actually, that affidavit is ready. Actually, we need
hospital.
In family members. He's looking after, so maybe 1 week's time, maybe.
Yes, further 1 week's time will be allowed to be joined.
Lordship.
Is there after?
Much less, Lordship.
122.
Please, Your Lordship. Lordship, we've received the affidavits of all the respondents. Respondent number 6 filed theirs last week. I humbly pray for 2 weeks' time, Lordship, to file a
You received
rejoinder.
3 and 4 last time.
Yes, Lordship.
You filed rejoinder 3 and 4.
No, Lordship.
You'll file one rejoinder to all affidavits.
That's the instructions we've been receiving, Lordship.
I'm appearing for respondent to Your Lordship. We have already filed our affidavit.
Who's number 2? Number 2 is?
Number 2 is the power grid,
Power
Lordship.
grid.
And 3 and 4 is?
The state.
MACL. 5. Year 4? Now who has to file? And 6?
6 has filed, Lordship, the same.
Who's for 6 today? You're for whom?
The district council.
Who's MSL Merchant? That's you. Okay. Yes, take down. You already filed 2 and 6 has filed. Who's appearing for 6?
I'm appearing for 6.
You file affidavit.
That's fine.
Yes, 6. Is the affidavit necessary or not necessary?
It is necessary, Lordship.
For 5 necessary.
Yes, Lordship.
Yes, MS Elmer Chang today prays for further 2 weeks time to file affidavit stuff. And the prayers allowed. How many times have you sought affidavit? You have no idea. We'll record that the order that he prays. He has no idea how many times has been sought. You check the other sheets. Yes. Prayers allowed stuff. Affidavits on behalf of the respondents already on board. To which Mr. LCM prays will be allowed.
2 weeks
time to file the joinder. Yes, let's up to 2 weeks.
Deeply obliged.
What orders? Yes.
Obliged, Lordship.
Obliged.
123.
Wait, please, Your Lordship. I'm praying for some more time to file an affidavit, Lordship.
When was this matter filed? 2-4. Well, there's some
March,
interim
Your
order in your favor,
Your
correct?
Lordship.
Yes,
We're yet to receive instructions, Lordship.
2 weeks time.
3 weeks, Lordship.
3 weeks for a time as prayed allowed to the respondents to obtain instruction to file affidavit stuff. Interim order ready to continue till next day. Is it
Obliged,
transfer
Your
matter?
Lordship. Your Lordship, this is a maternity leave matter. The petitioner had sought maternity leave and the respondents have not considered her representation, Your Lordship.
By
till
the
date.
time they file affidavit, maternity leave period will be over also.
Your Lordship.
124.
Obliged, Your Lordship.
May I please, Your Lordship? Your Lordship, I pray for 2 weeks' time to file an affidavit, Your Lordship. On behalf of
How many times have
Tiangi.
you prayed?
It's on behalf of Tiangi, Your Lordship.
On behalf of Tiangi?
Yes.
She has to file affidavit or the state?
Yes, Your Lordship.
Yes, Mr. Marat.
Yes, Lordship.
Yes, for a 2 weeks time has prayed allowed to affidavit. Yeah.
125.
My lord, here state is 1, 2, and 3. Mr. D is out of the station. I am praying for a week time, my lord, to file the affidavit.
4 and 6.
4 and 6 I am hearing.
You already filed?
We have already done with preparation and we'll be filing
No,
during the
have you
course of the
filed,
day.
yes or no?
We'll be filing it during the course of the day.
5. You filed?
No, Your Honor, I
Yes.
no objection.
When was this matter filed?
2026.
Yes, respondents pray for us for a 2 weeks time to file the respective affidavits. Yes, sir, after.
126.
Please, my lords. My lords, this is the matter of defreezing of the account. The bank had asked for a week's time to ascertain the disputed amount.
Where's Mr. Marpan?
He's not here.
After some time, let him come.
107.
Your Lordship, I need 2 weeks' time, Your Lordship, to file my affidavit. I'm appearing on behalf of respondent number 4.
Yes.
I need 2 weeks' time, Your Lordship, to file my affidavit.
Respondent 4 is the chief, Lordship.
I'm from respondent number 4, Your
Where's
Lordship.
1 to 3?
1 to 3 is a district council, Your Lordship.
So
Any
far,
interim orders? No.
Lordship, no. So far as 5 is concerned, Lordship, we had the notice has been delivered, Lordship. We had filed an affidavit. It was delivered on 29/4/26.
Yes. Yes. This also for number 4. Praise funds up for a 2 weeks time for activate stop. None appears for the respondent 1 to 3. The next after that, Mr. Emil Mampur submits that service since the responsibility has been served. Please allowed to file a after indicating
Lordship,
service.
it's already filed in the registry, Lordship. Lordship, I have some submission, Lordship. Since it's delivered on 29/4, till date there's no representation. I may be allowed to take step by dusty service, Lordship. Yes. Because they are important respondent.
Has been served since
29/4/2026.
But however, there's no appearance. So he prays that we have to further notice by personal dusty service. So he has allowed this after 2 weeks.
128.
You first rectify your transmission. Yes.
May please, Your Lordship.
Shut them down. Yes.
Lordship, they were supposed to file an affidavit on
I
this.
pray for 2 weeks' time, Your Lordship.
Hello. Oh, Philip.
My lord, for the past couple of
Philip, Yes. Yes, what do you want?
They were supposed to file affidavit on this.
You are paying for the petitioner?
Yes.
Yes.
I pray for 2 weeks' time, Your Lordship, to file an affidavit.
Yes, for a 3 weeks time, let's pay.
Lordship, there is a missed case which we haven't mentioned earlier. It's regarding the stay on the show cause notice dated 26/3/2024 issued by the respondents.
Dr. You take up a prayer for interim stay. Where miss case?
Yes.
Matter we take up together next day. Yes.
Oblige, Your
I
Lordship.
oblige.
129.
Yes,
Well, for respondent number 1, 2 and 3, I was appearing. I've sent the affidavit for vetting, my lord.
1, 2 and 3 is whom?
The chairman, secretary and the vice chairman, one of the vice chairman.
Oh, Mara Municipal?
Yes, my lord. DSC.
1, 2 and 3, 4, I think.
Or DSC?
I'm for respondent 6.
So I'm from respondent 5 or 7, Your Lordship.
1, 2, 3.
1 to 3.
You are appearing. Then what about this?
4.
So I'm from 5 and 7.
I'm for 6.
What about the other?
8 to 14. We have actually taken a step to serve orders.
What about 6?
I'm applying for 6.
You until today?
No, I have already filed. No, last time was
It's not
5
recorded
to,
here.
Last time was 5 to 7.
Last time 5 to 7, Mr. 1 to 3, Mr. Dave. 5 and 7, Mr. Kriyam. Today's Naitang. Yes, Mr. S. Deb at the appearance today on behalf of respondent number 6. Stop. What about the other respondents?
We have taken a step actually on the same day on 16/5/2026 to all the private respondent till 14.
11.
The 11 instruction address.
Okay, 11.
Who's appearing for 9? 9 on appearing. Mr. S. Kept an appearance today on behalf of the respondent number 6. With regard to respondent number 9, office note indicates that notice has been served up. ED cards have not been received with regard to respondent 6, 8, 10, 12, and 14. So, as far as respondent number 11 is concerned, the notice be returned unserved due to insufficient address. Stop. Petitioner 2 take fresh steps on respondent 11 and obtain status of service on the respondents 6, 8, 10, 12 and 14.
This matter can be disposed of, my lord, in the admission hearing stage. Because
now then, what do you have to say?
Yes, my point is this, my lord. The basic foundation of my petitioner's case is on the typing speed of the respondents. Now, these are the documents, my lord, which he has enclosed. My lord may kindly see from page 39 onwards, my lord, Annexure 4.
Yes.
My lord may kindly see typing test completed 2nd 4 2026.
Yes.
Typing master. Now date is 6/11/2024. It is a manufactured document which he has enclosed to build up his case, my lord.
How do you say that?
I am saying because I have the record, my lord.
Now the typing test is completed on 2/4/26.
26.
They took the test on 6/11/24.
Yes, how it can be, my lord?
It was on 6/11 only.
6/11. Now he has from where he got,
but not
just
it was 24 only.
24 only.
6/11/24.
Now, my lord, from what is the source of these documents, my friend has not disclosed. Very interestingly, he has enclosed the respondent type speeding this result, my lord. But he has not enclosed his own document. These are all fake documents, my lord, which has been enclosed by the petitioner, my lord, to build up his case.
Now, where did he get this from? Is there screenshots?
This one is we got it from the staffs only.
From RTI?
Yes.
No, my lord.
So we filed the RTI also. This
No,
one.
that is
And then,
totally false.
Lordship, if their submission is that, then we also ask for the inquiry. Let the inquiry.
Please listen.
Lordship.
You obtain these in a clandestine manner.
No, we have another document, so this is not a candidate
The
manner.
original which was there, the candidates had signed each of them. These are none of them are signed.
It is not only the candidate who has signed, the authority concerned who was present on the types on the test, my lord, they have also signed.
Therefore, we ask.
Now, my lord,
file affidavit if it's
yes,
correct.
also, I may be permitted to file a preliminary objection only, my lord.
Yes.
I will file a preliminary objection.
Yes, Mr. SD, however, on behalf of 103, has raised serious objections to the contents of the petition and has submitted that the documents annexed to the annex are manufactured and have obtained in an illegal obtained from whom we said
from the staff
obtained in a clandestine manner, not through official sources. The praise is allowed to file a preliminary objection to the petition and that the matter be posted for adoption hearing. Stop. Next paragraph. On submission of the Council 1, 2 and 3, we pray that the affidavit be filed within
2 weeks, my lord. Preliminary objection I will file.
And the matter be posted for adoption hearing thereafter. Stop.
And one more thing, if it can be recorded, my lord, that the enclosure, the annexures which he has put, my lord, in the petition, he has not made any statement from where. Now he is saying that
let him say it.
That he has not said. My lord.
Your lordship, I'll be filing my affidavit as well, lordship.
But if that's correct, Mr. Sangwan,
that is correct, my lord.
I have asked for inquiry, lordship.
Who is he to ask, my lord?
What inquiry you ask for? You can't.
Who is he, my lord?
They have manipulated. I will satisfy the court.
Because I have not conducted that inquiry, my lord. That doesn't mean that he is truthful.
No.
Yes. Yes.
130.
Please, your lordship, the respondent is supposed to file the affidavit, your lordship. Yeah, please, your lordship, praying for some time, your lordship.
You got what is the matter about transfer?
Yeah, no, your lordship,
Dismissed,
he was dismissed from service, your lordship, due to pending criminal cases, your lordship. Yes.
2 weeks further time. That's great.
Much obliged, lordship.
131.
Please, your lordship, I pray for some more time to file an affidavit.
The fresh matter is.
Yes, Your Lordship.
What's the matter about?
Should these are pertaining to staff nurse in Assam Rifle, Lordship?
It's upgrade for the 3 weeks time allowed for affidavit. Yes, thereafter.
132.
Wait, please, Your Lordship.
Yes.
Your Lordship, a corrigendum has been issued, Your Lordship,
Regarding?
with regard to the show cause notice.
Lordship, after the matter was filed, now they have come with the corrigendum, Lordship. If I may.
Yes, so we close it now.
Lordship, there are 3 aspects, Lordship, that will have to be addressed, Lordship. Now, the problem is, Lordship, this is the same case, Lordship, that is pending before the district judge, Lordship. Lordship.
You still allegations, you've got them.
Lordship.
Yes,
Lordship, then may have it day after tomorrow for instructions, Lordship. Because
what do you want to sustain now?
Lordship, the other aspect is that, Lordship, this is
You can't enlarge the scope, Mr.
Lordship,
Chandra. You understand very well.
Lordship is well aware. Lordship is well aware of the law that Lordship parallel proceedings cannot go. Lordship, and it is,
Of course they can go.
Lordship, will satisfy Lordship. Lordship may have it day after tomorrow. Lordship.
See, what is your prayer here in the petition? Okay.
They're aggrieved by the previous show cause notice, Your Lordship.
Yes. You have to stick to your pleadings and your prayer.
Lordship may have it day after tomorrow. We'll take instructions, Lordship. Day after tomorrow, Lordship.
Yes, sir. Today a corrigendum has been produced, dated 15 June 2026, to the show cause notice issued to the writ petitioner. So this court has perused the same and notes that the allegations have been detailed therein. As such, the limited prayer made in the writ petition no longer survives. Accordingly, Ms. S. Chanda has prayed the matter be adjourned to seek further instructions. But in view of the developments, no purpose will be served to retain this matter upon the same disposal.
Obliged, Your Lordship.
Lordship, in that event, Lordship, what has happened is,
yes,
this corrigendum was served to me.
Liberty to re-agit the matter.
No, Lordship. What has happened is, Lordship, the corrigendum has been served to me on 15, Lordship. So, Lordship, they have given me a time frame of 10 days, Lordship, to file, and this matter, Lordship, will take some time, Lordship, at least 2 weeks time to give it, Lordship.
Mr. Chanda, yeah, that's it. However, Mr. Chanda has no, Mr. Chanda, what do you own now? Yes. Single instructions. Single instructions. He submits that as the corrigendum to the show cause received only 15.
Lordship, 10 days has already lapsed, Lordship.
And 10 days has been given. He prays that the petitioner be allowed
2 weeks time, Lordship.
Be allowed 2 weeks time to file reply.
Lordship.
There to start. Next paragraph. Yes, this court views the development. No purpose is served to retain the matter, and the petition is disposed of. However, by allowing the petitioner 2 weeks time from today of the order to reply to the said show cause.
Obliged, Your Lordship.
133.
But we have sought for instructions from the district level, Malad. It's still awaited. The department has written to the district. This second round, Malad.
But the one person has been kept in detention center.
Yes, Malad, I understand that, Malad. Malad, we are seeking for instructions.
But Mr. Gurung has maintained steadfastly that no records are available anymore. That the whole DC's office burned down how many years ago?
Malad, that is the issue, but we are trying, Malad. If there's any digital record or something.
Yes.
1 week, Lordship.
That will be 2 weeks.
Yes, Mr.
Lordship,
Perumal,
the person is in detention
the-
kept on it.
for 1, 2, 4 and 5 cases are allowed 2 weeks time as instruction yet to be received. So praise allowed, yes, list up to 2 weeks.
Deeply praised.
Second call, 106.
Please, Your Lordship, the bank has no objection, Your Lordship, to the unfreezing the account. As far as the disputed amount is concerned, the bank cannot confirm that, Your Lordship. So a simple
Can't
unfreezing.
confirm the amount.
Amount.
Freeze the entire account then.
Yes, sir.
Yes, Ms. S. Marpan to submitted that the bank respondent number 1 has no objection to the freezing of the account of petitioner, notwithstanding the fact that the amount to be kept in DN is not known. So, in view of the submissions made by the counsel for the respondent number 1, directed that the bank shall defreeze the account of the petitioner. You've given a number here, being so and so and so.
1 week.
Within 1 week from Pedro's order, matter stands disposed of.
Wait.
Pleasure.
Hearing.
Quick order name of the account number.
134.
Give me that bunch of papers.
May I please, Your Lordship? A small rejoinder that I would like to give against the submission made by the respondents, my lord.
When was the matter last heard? Last monthly hearing. April.
Yes.
So, what I could have summed up, my lord, from the submission of the respondents, that since the petitioner had applied for general, my lord, respondent number 6 appointment cannot be challenged because he has been appointed for OBC category, my lord. And respondent number 7, my lord, whose appointment is also under challenge.
Just let me. You were on now, Mr. Sen has, I think, justified by separate
yes
interview.
Yes, my lord.
Yes, no, he is replying on that, and he has placed that there were old ordinance and new ordinance.
And that yes, that OE.
Yes,
I'll clarify.
3 clause 6.
Yes.
Then he refers to the first judgment in a compilation.
Yes.
Then he has attacked the screening committee.
Yes.
Then he has he said in zoology there was no external examiner.
Yes. Yes, my lord.
Yes. Okay.
Yes.
I'm looking at my notes, but I don't know. I don't think I can connect the dots any longer. Therefore, yes, this is background fact. Yes. Now you're replying to.
I'll reply to the point of screening committee. What was interpreted by learned senior appears not to be correct, my lord. I will like to highlight on that, my lord, that the screening committee which was constituted, I have got it on record, my lord, by way of an additional affidavit dated 20th March 2026. If my lord may kindly take that affidavit, my lord, use that affidavit, page 8 of the affidavit.
Filed on?
Filed at 20th March 2026. I was permitted by this honorable court, so I file it, my lord. So basically, my lord, my contention is this,
If my lord produce page 8 and see my lord 5B, 5B1, screening of application. Screening of application has to be done and then it has to be forwarded to the HOD. B, screening of application. The application of all the candidates for the post of assistant professor, associate professor, professor or equivalent post shall be forwarded by the university office to the HOD concerned, which shall ordinarily be the chairman of the screening committee. Now, then, my lord, they have distinguished, my lord, that if the HOD is not there, my lord, yes, my lord, and however, if the HOD happens to be an associate professor, then what should be done? The senior most professor in the department failing which? The dean of the school or the vice chairman. The head of the department shall constitute a committee and not less than 3 teachers in the department, not below the rank of associate professor, including the professor in the department or from other department in case there are not enough faculty members in the department to screen the application for the post of assistant professor, associate professor and equivalent, and for preparing a list of candidates for interview. Similarly, my lord, this is important. Similarly means if I can submit, my lord, not in isolation, my lord, it has to be read together, my lord, not in isolation. Similarly, a committee shall be constituted by the HOD or the senior most professor or the dean of the school or the vice chancellor, as the case may be, for scrutiny the application for the post of professor. So my understanding and my interpretation is this, my lord, that the professor, if it is a professor for the post of professor, my lord,
yes,
for the post of professor, it is the professor, sorry, my lord, it is the HOD who should chair the committee, my lord. If in case there is no professor, my lord, then the dean, my lord, or if in case that also fails, my lord, then the vice chairman comes to play, my lord. Now, there is 2 parts, my lord. If my lord may kindly see, this committee shall comprising of not less than 3 teachers. Else shall
you just come to that similarly.
Similarly,
okay, the last line. Similarly,
a committee shall be constituted by the HOD
or the senior most professor,
yes, or the dean of the school or the vice chancellor, as the case may be, for scrutiny the application for the post of professor.
Okay.
If we go with their interpretation also, my lord, we have no quarrel in this point, my lord. But the fact is this, my lord, thereafter what is required to be done, this committee shall comprise of not less than 3 teachers and shall include all professors in the department and at least 1 professor from other department in the school or other another department in the school or other school. Now, my lord, that they have not answered. Why another professor was not included in the screening committee from the other department? Now, my lord, I would like to show, my lord, the compilation that I have given, my lord. You can decide. If my lord may kindly produce the compilation, my lord, page 33, my lord.
1 second.
The last compilation that I have submitted, my lord. Page 33, my lord.
Judgment?
No, my lord. Compilation. The last compilation that I have given, my lord, of those
acts and ordinances.
Yes, my lord. OE3, my lord. I have given OE3. It's compilation. Yes. If my lord may kindly produce page 33, my lord.
Yes.
My lord, may kindly see, this is a notification in connection with zoology, my lord. Now, Professor N. Shah, who is the Dean of Life Science, is not the HOD, my lord, of the department. Now, this notification says, my lord, that Professor Shah,
so according to your submission, that the non-compliance or
adherence of the non-adherence or
adherence to this
OE3
procedure of scrutiny.
OE4, my lord.
It will vitiate the entire
yes, my lord.
process.
Yes, my lord. That is my submission, my lord. I will place
It's
the
not a
judgment.
minor irregularity that can be overlooked.
No, my lord. It cannot be. It is where, my lord, a person has to be, a person is required to be determined, my lord, whether he is competent for that post or not, whether he is qualified or not, my lord. Now, my lord, this is the zoology, my lord. My lord, I want to place 2 more notification, which for the other department they have notified. On the same day, my lord. On the same day, my lord, may kindly come to page 34.
Yes.
This is a notification by which a committee was constituted for botany, my lord.
Yes.
And the botany HOD was made the chairman. And my lord, for just remembering, my lord, botany comes under life science. Botany comes under life science.
Biochemistry. 34.
Yes. My lord, what is my point is here.
Botany 36.
Yes, my lord. Botany 36, my lord. Then, my lord, may kindly see another notification on the same day which was published, my lord, that is of biochemistry. Biochemistry? Yes, biochemistry, botany. Now, my point is this, my lord. If my lord may kindly see the advertisement by which the notification was, the post was published, my lord. The notification says, my lord, in the life science, zoology, biochemistry and botany. And the dean of that is N. Shah, my lord. Dean. Now, if for any reason the dean had to be accommodated because of his seniority, they should have clearly stated in the notification, my lord. In the notification, they are now in the affidavit, they are trying to polishing their misdeed, my lord. My lord, may kindly see, if Dean was N. Shah, my lord, he should have been the chairman of botany also and biochemistry also. Why particularly of zoology, my lord? And other 2 departments, my lord, they have given to the HOD. Why in my case, my lord, they have not given to the HOD, my lord? And moreover, my lord, the relevant point is this, my lord, that the external professor from a different department was not added, my lord, or not included.
Is Dixit?
He is from zoology, my lord.
No, but is he external officer? He is not external professor.
No, my lord. My lord, may kindly see, his name is reflected 2 times, my lord. A.S. Shah in serial number 4 and number 7. Dikshik, my lord. A.S. Dikshik. He is from zoology, my lord. So my submission is this, my lord. The screening committee get vitiated because, my lord, an external member has not been included, and moreover, the chairman was dean of the school, my lord, not of the department. The law says, or the statute of NEHU itself says, my lord, it has to be the HOD, my lord.
No, but it says that, see, similarly, a committee shall be constituted by the head of the department or the senior most professor or the dean or the vice chancellor, as the case may be, for scrutinizing the application of suppose a professor or equivalent. This committee shall comprise not less than 3 teachers and shall include a professor in the department, at least 1 professor from other department, the school, other schools.
Yes.
So what does it say? There's no mandate that it's mandatory the head HOD should be there.
My lord, that is what I have submitted, my lord, on my first round
of vice chancellor or the senior professor.
No, my lord, that is what I am saying, my lord. It cannot be read. This screening committee screening committee of application, my lord, 5B, 1 cannot be read in isolation, my lord. Similarly means it has to be continuation, my lord, of what they have stated for associate professor and for assistant professor, my lord, and also for professor. My lord, may see the starting of the paragraph what it says, that the application of all the candidates for the post of assistant professor, professor, associate professor or equivalent post shall be forwarded by the university office to the HOD concerned, who shall ordinarily be the chairman.
Be the chairman.
Yes, ordinary be.
Ordinary means like in usual course he shall be the chairman.
Yes. However, now this is very pertinent, my lord. However, if the HOD happens to be an associate professor, that is the exception, my lord. That is why OR has been added.
Yes.
The application for the post of professor or equivalent shall be forwarded to the senior most professor.
Yes.
And if he is not there, my lord, in the department, then it will go to the dean of the school or the vice chancellor, my lord. So there is a caveat according to my understanding, my lord. If it fail, then second part comes, then third part comes, and then the fourth part comes. So that is my interpretation, my lord.
Who was the HOD of zoology that time?
At that time, my lord, the member, serial number 2, my lord, Professor B. Roy was the HOD.
Then he's there.
He is a member, my lord. He should have, my lord, he has to chair.
If the dean is senior to him, then he'll chair it.
No, if that is the case, my lord, then in the notification, they should have contemplated, my lord.
Like,
and moreover,
can't contemplate any eventualities.
My lord,
if you know, what do you call it? Anyway, continue, yes.
My lord, if I can say, my lord, on instruction, my lord, he is not senior. Mr. Shah is not senior to me, my lord. Senior to the Mr. Roy.
The dean of the school.
He is dean of the school, my lord. Dean of the school, my lord. In the school, my lord, there are 3 departments, my lord. 4 departments, my lord. So he is not that, my lord. He is senior in the department, my lord. He may be the dean of the school, my lord. School comprising of 4 departments,
Biochemistry, botany, zoology,
and biochemistry, my lord.
Yes.
But even if this ground, my lord, doesn't stand, I feel, my lord, this ground has a merit. But even if my lord doesn't appreciate my submission, my lord, but the external member, which admittedly has not been included, my lord.
External member.
External member, my lord.
Okay.
Whereas in botany and biochemistry, they have followed that, my lord. And more interestingly, my lord, the respondent number 6 application was rejected by the botany. By the screening committee itself. It's not by the selection committee, my lord. By the screening committee. My lord, according to me, my lord, prima facie the notice is inconsistent with OE4, my lord. And my lord, what I can further submit that failing to add the external member is not, my lord, is optional, my lord. They shall. The language, if my lord may kindly see. Otherwise, they would have said, my lord, that they may include if necessary. That is not the case here, my lord. This very specifically they said this committee shall comprise of not less than 3 teachers and shall include all professors in the department and at least 1 professor from another department in the school or others, my lord. So if this point stand, my lord, I need not argue on any other points, my lord. If this stand, my lord, my submission, my lord. And why I have the right to challenge, my lord, basically, is because, my lord, here a person was given chance 2 times, my lord. But if my lord may kindly see the OE3 and the advertisement or any other documents that they have placed, my lord, I don't think so they have placed any documents, my lord, which allows a particular person to apply 2 times, my lord. I would like to take, my lord, to the and to be interviewed twice, my lord. I would like to take, my lord, to the note to OE3, my lord, in my compilation.
6.
OE6, my lord.
No, OE3.
OE3.
Clause 6.
Yes, yes. Yes. We will follow the old one.
Selection committee shall interview the candidates belonging to the scheduled caste.
Yes, my lord.
Yes.
This is the selection. Now, I would like to take, my lord, to both the notification, my lord, which they have one notification they have not placed. We are placing both the notification. If my lord may kindly see OE 3-6, my lord.
Yes.
It says the selection committee.
Last time we had placed this.
Yes,
but I have it in my notes. Yes.
Yes, my lord.
Yes.
The selection committee shall interview the candidates belong to the scheduled caste and scheduled tribe for the post of lecturer separately and make it recommendation before other candidates are interviewed. It doesn't say, my lord, anywhere, or neither it state in the advertisement that a person need to apply twice if he is from the reserve candidates. According to my understanding and the law, my lord, that I am going to place, that compilation law, my lord, I have already placed, that a person cannot be allowed to file 2 applications, my lord, and interview twice, my lord. My lord, if my lord visualize, today I appear before my lord put me 2 questions, I am not in a position to answer, I go back, prepare it, and the same question was put to me, I answer it, and I get full marks. Can it be allowed, my lord? Normally what happens, my lord? a person of reserve candidate, he can be accommodated in the unreserved seat, my lord, on merits, my lord, if he is better than an unreserved candidate.
That is...
There is a settled law, my lord. There is a settled law.
Yes.
My lord, may kindly see again, my lord, the notification of the latest notification of 25/7/2019. That is on page 5, my lord. Of compilation. This compilation only, page 5.
Yes.
6, my lord, again 6. When selection committee meeting are convened for the post of different categories together, it very categorically says, my lord, together. Candidate for the reserve categories post shall be interviewed separately and recommendation made before candidates for unreserved categories are interviewed. So here is a scene when, my lord, a reserve candidate should be interviewed. Preference is given just to be interviewed fast, my lord. It doesn't say anywhere, my lord, that they can be interviewed again for the general seat. And moreover, my lord, if this is that the interview or the selection process was too different, my lord, that is wrong. It cannot be allowed and it doesn't contemplate by clause 6, my lord. It is together, but preference will be given first to them and the recommendation has to be made before the general. In this case, my lord, recommendation was made at the same time, my lord. He was the only one who was interviewed twice. Recommendation was made on the same day, my lord. My lord has to examine the record, my lord. That will speak volume, my lord. Why I am saying that the recommendation was made on the same day? It should be before, my lord, the unreserved. It was made together, my lord. They have to produce the minutes, my lord, whether the recommendation was made prior to the recommendation of the unreserved candidate, my lord. Well, on this point, my lord, I will place the judgment again, my lord, of this is the compilation of the judgment, my lord. Pradeep Singh Dehal, my lord, versus State of Himachal Pradesh and others. Now, this judgment was interpreted by Malala Senior that it is a state university, it is not a central university. My lord, this OE, when it was published, my lord, the first OE came into effect from 2nd June 2022 and the first 2nd June 2022 and the last is 25/7/2019. This was taken into consideration, my lord, while passing this judgment, because this judgment was pronounced, my lord, on September 2019, my lord, after the OEU was published, my lord. Now, my lord, what I am highlighting or buttering my submission, my lord.
So the only thing, Mr. to cut down the,
my lord,
the only challenge is one, that screening committee was improperly constituted.
My lord.
Number 2 is that separate interviews are permissible as per OE3 clause 6, but the separate interviews, separate results, first results for SC/ST should have been.
Yes, my lord. Yes, my lord.
Then later on the interviews unreserved candidates should take place, and then the consolidated whatever.
Not exactly published, my lord. It has to be recommended only.
Okay,
recommended, my lord.
Then after that, the interviews held for the unreserved candidates. Correct,
my lord.
Now your case, you say firstly the screening committee is
the composition of the screening committee.
The composition is faulty.
Yes,
which has vitiated the screening process. Number 1.
Yes,
and even come to selection also that the petition of the respondent number
6, my lord.
That is Mr. Changseo Klein.
Yes, ma'am.
Would not have been allowed to, to take 2 interviews.
Yes, ma'am.
For the same job.
For the same.
One as in the separate one.
Oh, yes.
As for OE3 clause 6.
Yes.
As for SC/STs, other one is for general.
Yes, ma'am.
That is basically
basic thing, my lord.
Yes.
only thing is that, my lord, what could have been permitted as per the law, a marks he scored in an interview, and that could have been considered in OBC or in unreserved, my lord.
Right. No, that's a given. That the marks get scored.
As in a common, my lord.
Now,
Yes, my lord.
Now you're saying that he got selected only the base the marks he obtained in the SC OBC, right?
Yes,
OBC
yes.
interview.
Yes.
That is your case.
Yes.
Right.
Now, according to my...
The only thing is that we have to satisfy the court in a sense that the writ petitioner taking... Firstly, okay, fine, whether you would have taken his place due to selection. That's a different matter which has been argued by Mr. Sen, I think. And second part is whether the whole selection process is vitiated because of this.
Because of this.
Allowing
And more,
sit twice.
this is on technical ground, my lord, because the screening committee composition was wrong. Second thing, whether he fulfilled the criteria of the advertisement or not.
Now, that's the third point.
This is the
Now
third
you're saying
point.
He doesn't fulfill the criteria.
He doesn't fulfill the criteria.
He doesn't fulfill the criteria because
he doesn't have 10 years of experience.
So he was rejected in the other.
One hand, he is rejected in the botany department, my lord. That record will be also placed before this honorable court, probably, my lord.
That's how this court understands it. That's all.
Yes, yes, my lord. Now,
bring it down to basics.
Yes, my lord. Now, why I'm saying that he doesn't fulfill the criteria of the advertisement? 10 years he doesn't have experience. He claimed to be an outstanding, my lord. The criteria has not been laid down by the Academic Council or by the Executive Council. As per the RTI, it is a selection committee which has given the finding that he is an outstanding, my lord. I don't know on what basis they have given. Now, if their own statute is not complied by the my lord, then my lord may take serious note of it, my lord. The next point is this, my lord.
Now, what do you want to show in the judgment?
This judgment I want to show, my lord, that the entire selection process goes, my lord. If two interviews, yes, my lord, para 14 of the judgment, page 7, my lord. Here, my lord, what my learned senior, Mr. Sangreso, has pointed out, that I have not made any prayer in connection with the screening committee, my lord. Here is the case, my lord, which is not even the case of neither of the respondent nor of the petitioner in this instant case. But the court find out, my lord, if I am permitted to read, we find out that the process of conducting separate interview for the post of assistant professor under general category and OBC is wholly illegal, though none of the parties has raised any dispute about it. But since the same is inherently defective, we are constrained to observe even every person is a general candidate. The benefit of reservation is confirmed to scheduled caste, scheduled tribe and OBC candidates or such other candidate as is permissible under the law. It is a consistent view of this code stated in so and so that if a reserved candidate can
Where
be
reading from?
Para 14, my lord, of the judgment.
Page
7, my lord.
The first judgment.
The first judgment, my lord.
First judgment is this Pradeep Singh Tehal.
Yes, yes, my lord.
Page 7.
Page 7. Para 14, my lord.
Okay, yes, sorry. On the judgment. Yes.
We find that the process of conducting separate interview for the post of assistant professor under general categories and OBC categories is wholly illegal. Exactly what they have done in the instant case.
But the rules allow it. In this case, doesn't allow.
No. What I am saying is this, my lord. It doesn't allow, my lord. You cannot.
There's separate interview.
No, my lord.
The finding here. We find person conducting separate interviews for the post assistant professor and other general category.
Yes.
And OBC category is wholly illegal.
Is wholly illegal.
No, I'm sorry, with due respect, but this is under your statute.
No, my lord.
That yes, OE6 says that separately. Then
no, my lord.
And if your recommendations have to come before that, that means a parallel process is not one process.
No, my lord.
Only the results will be one process.
What I am submitting is this, my lord.
Yes.
A same person cannot be interviewed twice, my lord.
Fine, that's what every person, like they say, is
here what happened?
Every person is contention for a general category seat.
Exactly,
right?
Lord. Exactly.
So if you score enough more general category, you take the open seats. Open means open.
Yes.
That's your case.
Yes.
Now you're saying that he didn't qualify for open. He qualified. Now if you take that day horse, whatever selection, he has qualified under SC. So what quarrel you have? Because you cannot fill SC post.
No, I'm not saying that.
The question of him taking open category seat after he qualified. In
my lord is trying to distinguish me on this point, saying that, my lord, I cannot be accommodated even if his appointment is declared to be illegal. But I could have understood what is fallen from my lord. My point is this.
Never in contention for the SC seat.
My lord.
You're in contention only for the open category seat.
Exactly, my lord.
And so he went for 2 interviews.
Correct.
So the open category, he's nowhere.
Yes.
And then he succeeded in the OBC category.
Yes, exactly.
So even if we set aside the selection, doesn't mean that you will get another chance to the SC seat.
No, my lord.
Was that unreserved one's already gone, correct?
What is my point is this, my lord. The entire selection process get vitiated, my lord. Entire selection process.
That's your case only.
That is my case, my lord.
That's what we have all observed that.
That is my case.
Look at the bigger picture now to unsettle this whole process.
Yes.
That observations can be made, but whether you will get in the relief. What relief will you go? You're not entitled to any relief.
My lord.
Even if you carry the case forward and the section vitiated, what does that mean?
My lord, let me see. What is my prayer, my lord?
Yes.
To set aside the entire selection process, my lord. I am not saying, my lord, that to accommodate me. The entire selection process, because, my lord, what is my submission, my lord? My submission also, my lord, cannot be taken in isolation, my lord, that one part. When a selection committee, the screening committee, I mean, my lord, is get vitiated, my lord, the entire process goes, either he is appointed in OBC or general, it is irrelevant, my lord. Second point of my argument was this, my lord, that a person cannot be given twice chance, my lord, for the same post.
That we noted. That also it's very strange. So yeah, that we noted.
Now, if they are relying on OE3, my lord, OE3 doesn't contemplate anywhere, my lord, that the same person can be interviewed twice, my lord.
Doesn't contemplate, but it allows a separate selection. That's all.
How it allows, my lord? With due respect, my lord.
You read OE3 clause 6 again?
Yes, my lord. The selection committee shall interview the candidate belong to the ST category and ST category for the post of lecturer separately. What does it mean, my lord? According to my humble understanding, separately means they cannot be taken all together, my lord. Separately, they should be given a chance. First, the first preference should be given to the unreserved candidate, reserved candidate. And that from there, my lord, the marks can be brought into the general categories. This is my understanding, my lord, and this is the practice which is going on, my lord. Now, for MBBS seat, my lord, in the state of Meghalaya, my lord, an ST candidate, on an SC candidate, an OBC candidate, they are placed in serial number 1 and 2, my lord. But it is not the case, my lord, they have applied for unreserved seat. They have definitely applied for the OBC, or they have definitely applied for the reserved seat, my lord. It is not the case, my lord, where you have to apply to, my lord.
Now, in this case, interview board is different, right?
Yes. No, it is same.
No, they have a member of the community.
No, same.
To be in the interview board.
My lord, may kindly examine the record, my lord. It is same. It is same people who have signed in both the documents.
There is no member from the
in both in unreserved also they have signed. In reserve also they have signed.
The same people.
Same people. There's no.
One belongs to OBC.
One belongs to OBC.
Well, that's all right. Then it meets the criteria.
We are not on that point, my lord.
No. You just see. The thing is that I'm just trying to roll it back to what the statutes and ordinances allow.
Yes.
Correct.
Yes.
So within that within that framework, that what is allowed and what is not,
my lord,
it envisages a separate selection, so that that petitioner can be faulted for appearing there. Now the only thing is that now whether he can appear in 2 selections. Now the other futile, he has not yielded a result for him.
Yes.
Right.
Yes, my lord.
So
I
what
agree.
impact will that second selection have? Will his appearing or being allowed to, due to the fault of the respondents in applying, sitting twice, will that have an impact on his current appointment under the OBC
it will be very interesting for my for this honorable court to find out, my lord.
It's ready to examine, but the thing is
that is what my lord has to examine.
We look at the end result.
My lord.
The end result is what?
Yes.
The end result is forget about. So forget he applied under the open category. Okay. He applied and he selected. Now, would he have a case then?
My lord, I remember the beautiful quoting of Justice BK Sharma, my lord. Sometime it happened, my lord, the operation is successful, but the patient died, my lord.
Yes.
My lord, many times he used to keep on repeating this, my lord.
Yeah, your case might be operation unsuccessful and patient died also.
Maybe, my lord, that is for my lord to decide. It's for my lord to decide, my lord. My point is this, my lord. When a person has already applied, can he be allowed to submit another form? And moreover, my lord also has to examine, my lord, that repeatedly the senior has put a caveat that my lord is not sitting as an appellate forum to examine whether he is qualified or not. But no law bar, my lord, to check, my lord, whether the candidate fulfill the minimum criteria to apply the post. According to my understanding, my lord, he doesn't fulfill the criteria, my lord.
Okay.
That is why, my lord, Botany has rejected. And then, my lord, in Delhi also, my lord, JNU has rejected. He is before the court, my lord. Notice has been issued, my lord. No stay has been granted to him.
In Delhi?
He's trying his luck in Delhi also. Probably he knows that maybe the court will interfere with this appointment. So, my lord, this for respondent number 6, my lord, my submission will be that he doesn't fulfill the criteria of the advertisement. 10 years.
Then his teaching experience.
Yes, 10 years teaching experience. Second thing, my lord, he has applied in category B, whereas he is not an outstanding professional, because NEHU has not laid down the criteria to declare or to reward someone as an outstanding professional, my lord. And 10 years has to be after PhD, my lord. And he has completed PhD on 22/6/2015, my lord.
What does the UGC say?
10 years, my lord, after
PhD.
After, yes. And my lord, I will try to rely on one judgment of Kerala High Court. They have interpreted this point, my lord, of 10 years. My lord, may I kindly see the compilation that I have given, my lord. So it is on page 11, my lord. Page 11 is the judgment of the Kerala High Court, my lord.
Yes.
Page 20 is the relevant para, my lord.
Page 11?
Page 11 of the compilation, my lord, is the Kerala High Court judgment. No, not the spiral binding one, the other one, my lord, where OE3 and OE3 has been
confusing now.
Not in this, my lord, in the other one, my lord. Page 11. The relevant para is on page 20, my lord. In this regard, I find great force in submission of so and so that when the stipulated criteria is stated by saying that candidate must be an outstanding professional with PhD degree and then qualified it with a requirement of having significant contribution for 10 years, it can only be considered that such contribution experience must be after acquisition of the doctoral degree. If the said stipulation is to be interpreted in any other manner, then it will even lead to a situation when a person with 10 years of experience prior to having PhD, but even with 1 day experience thereafter will be available to apply.
Single judge.
Yes, this is a single judge.
I think we'll have some reservations about this anyway.
My lord, may distinguish this with my lords.
Don't distinguish, you don't accept it at all.
My lord, my lord.
Yeah.
But that is a settled law, my lord. So, my lord, para 10.
Yes.
Para 10, my lord. I am left without any doubt that thereafter the stipulation in exhibit P1 notification of having 10 years experience can only be considered to be that which a candidate acquired after doctoral degree was obtained. On the same ground, my lord, JNU has also rejected, my lord. Same ground.
10 years.
10 years, my lord. And it is there already. Yes, and I I have taken, my lord, to the regulation, UGC regulation, clause 10A, page 94, my lord. How to count the 10 years experience, my lord. Clause 10A, page 94 of the spiral binding that I have given, my lord. UGC regulation 2018. The small UGC regulation I have already given, my lord. Page clause 10A, page 94, my lord, of the regulation.
Isn't here?
No, on this separate, my lord. I have given a small regulation.
Because very difficult to traverse all
This is the regulation that I have given. Yes. Entire UGC regulation I have given. Otherwise, I'll supply one copy if it's not there. I will supply, my lord. Is there extra? My lord, may kindly just.
That one?
No, no, my lord. I will just.
How many are you giving? Becomes.
We have already given. Yes.
1 second.
10A, my lord.
You have one compilation here. Then you have
a small compilation of UGC regulation only.
Okay. The many judgments have been given loose copy, some have been given compilation.
Only 2 or 3 I am relying on that, my lord, but I will give the booklets, my lord, which I am relying on with the paragraphs.
That's very easy for the lawyers to argue and place, and then and when time
Sorry,
comes
my
for judgment, just to take out from the file. Yes.
Counting of past service for a direct recruitment and promotion under CAS. Previous regulations, this A, my lord, I am relying the essential qualification for post held were not lower than the qualification prescribed by the UGC for assistant professor.
Where are you reading from?
This page 94, 10A, my lord. A, my lord.
Yes.
The essential qualification
for professor.
Yes. No, this is for assistant professor, and professor. The essential qualification for the post held here not lower than the qualification prescribed by the UGC for assistant professor, associate professor, and professor, as the case may be. Now, my lord, may kindly skip the others and come to clause F, my lord. So, for the ad hoc or temporary or contractual service, the minimum qualification prescribed for assistant professor, associate professor, and professor, as the case may be. So now, my lord, may kindly come to page 60, my lord. What I am submitting is this: the minimum qualification for applying is the assistant professor. Now, what is the qualification for an assistant professor? Is, my lord, 10 years after a PhD. Page 60, my lord.
Professor EOB.
Yes, my lord.
That we've seen it earlier on.
That, my lord, I have taken, my lord, number. Yes, patient, my lord. So 10 years, my lord, the minimum qualification is PhD, and it has to be, my lord, after PhD only.
What about this B?
B is the outstanding, my lord. Outstanding. Respondent number 6 is coming under this category.
Is he come under B? He come under B.
He is come under B, my lord. So he could not have.
What do we have with him coming under B?
Sorry, my lord.
What objection do you have under B? What's the objection? You said
He's not an outstanding professional, my lord.
how do you know? How did he gauge that?
As per the UGC regulation, my lord, it is the academic council or the executive council.
They have to get certificate.
There has to be a criteria which is laid down, which should be laid down by the academic council.
They don't have that.
They don't have, my lord, and in their affidavit also they have stated, my lord.
So
And
they can consider outstanding professional just like that.
they cannot, my lord. The selection committee cannot, my lord.
Cannot.
They cannot, my lord.
There has to be certificate.
By the academic council, my lord.
It's not a question of appraisal or of his work. No.
No, my lord.
How is it done? Has it any other case happened where a person
No,
does not have the
if
basic
my lord may kindly see,
qualifications, but on the basis of outstanding professional gets consideration
if my lord may kindly come to page 76, my lord.
of this UC regulation?
Oh, yes, yes, my lord.
Yeah.
'76, my lord. Was 5, my lord.
Yes.
6(5), my lord. In case of selection of, if I'm permitted to read, my lord.
Yes, yes.
In the case of selection of faculty member who are from outside the academic field and are considered under clause 4 so and so of this regulation, the university body, statutory body, must lay down clear and transparent criteria and procedure so that only outstanding professional who can contribute substantially to the university knowledge system are selected. Now, who are the statutory body, my lord? As per the RTA, it is the academic council and the executive council, not the screening committee, my lord. And in addition to outstanding professional, my lord, experience of 10 years.
Okay. So he's not fit to even cross the doorway.
Yes, my lord. That is my, and the screening committee should not have allowed this, my lord. Now,
so that you have covered you're not eligible. Then you have covered that he's done twice interview.
Yes, my lord.
Then okay. Then screening committee is faulty. No HOD.
My lord.
Head the committee.
Yes, my lord.
And no external member. Those are
the things, my lord. That I'm just yes. Now, for respondent number 6, I rest my case, my lord. Respondent number 7, my lord. Now, respondent number 7, my lord. If my lord may kindly come back to the advertisement, with that I have enclosed, my lord.
An ending argument, then, Mr. D.
No, my lord. Only 3 minutes, my lord. I will take for respondent number 7. 3 minutes, my lord.
It was 7 responded by? Or yes.
My lord, zoology, the advertisement was for zoology in page 35 of the red petition for the professor post. 3 post was advertised.
Yes. One UR, one OBC, one EWS.
Yes, yes. And respondent number 7 was appointed and UR. Now my respondent number
unreserved. Okay.
Unreserved, my lord. I have also applied for unreserved.
What's his qualification?
His qualification was MSc in biochemistry, my lord. Biotechnology, my lord. And he is claiming that he have with the specialization, my lord. These are the specialization. Now, why I have taken, my lord, to the advertisement? For one reason, my lord may kindly see serial number 13 is the zoology and serial number 14 is botany. In botany, my lord, in the last column, that is in the right hand side, first column of the right hand side, they said specialization is desirable.
Yes.
But in my case, my lord, it was not desirable. They should have this specialization. Now, my lord may kindly see the affidavit which has been filed by the respondent number 7. He has nowhere stated that he is from the zoology background. And he has not stated.
But it is connected. Last time we argued this one, he's connected to.
That is the argument of respondent number 7, that it is connected, my lord. My understanding is this, my lord. He doesn't threshold, my lord. The threshold of the advertisement is that a person from the zoology department required a specialization in a particular field, my lord. Now he is not from zoology, my lord. First thing, he has done his MSc. If my lord may kindly see. He has done his MSc in biotechnology, my lord, nothing to do with zoology.
Okay. Where is it stated that?
He has stated in page 10 of his affidavit, my lord.
He's filed one affidavit.
He has filed one affidavit.
Yes.
MSc in biotechnology and PhD, my lord, in life science. Now my submission.
MSc in biotechnology.
MSc in biotechnology
and PhD
in life science. My submission will be for respondent number 7 will be this, my lord, that he doesn't have the requisite qualification as per the requirements of the advertisement.
Let's see annexure 1 of his affidavit.
Annexure 1. Annexure 1. 2.1 academic qualification, my lord. 2.1 academic qualification.
Yes. Master's degree biotechnology. It is the yes.
My submission is this, my lord. The requirement of this advertisement contemplate, my lord, that specialization has to be in the master level, my lord, master degree, my lord. For example, my lord, if I can illustrate, my lord, by an example, I have done BSc chemistry honors, my lord. Now I have done my law. Then, my lord, I do PhD in an arts subject. I am permitted if I clear a NET, my lord. That doesn't mean that, my lord, I have done an MA or a BA. But if the requirement is that, my lord, that I have to do specialization in master degree where I have not done my MA, how can I claim, my lord, that I am specialized in MA, my lord? Even if I have done something of an art stream in the higher level.
I find it very confusing to follow. Please simplify it. Yes.
My lord. Like for example, my lord, I have done chemistry BSc honors, my lord.
Right, you study law.
Then I study law.
The benchmark is you have to graduate to study law. Okay.
Yes, my lord.
Fine.
Then what happened, my lord? In PhD, I have done an arts subject.
Yes.
Because I have acquired some knowledge of arts in my law. Now, in a particular subject of arts, I have done my PhD or I have done my research and all. It doesn't implies, my lord, that I have done my specialization in master degree level, master in arts, my lord. I have not done. That is what is my understanding, my lord. I am open to be corrected, my lord. And so his specialization, my lord, it was in the PhD level, my lord. If at all, my lord. Now, my lord, zoology, biochemistry and biotechnology, my lord. Now, if we take only of biotechnology, because the respondent number 7 has done his master degree in biotechnology, my lord. Neither the respondent number 7, neither the NEHU, my lord, has placed any document where the academic council or the executive council or equivalent committee, my lord, has declared biochemistry or biotechnology to be an allied discipline of zoology, my lord. They have not said or they have not produced any document, my lord.
Does it come to school life sciences?
No, my lord. Life science is like a school, my lord. For example, my lord, university. University may has different departments, my lord. It doesn't mean that university becomes a subject. University cannot itself become a subject, my lord. That is my understanding, my lord.
Okay, yes. PhD in life science, you said.
Yes, PhD in life science.
Yes. And
But no
MSc
specialization.
in biotech.
Biotech, my lord.
So
Biotechnology.
no specialization, you say.
Yes, that is what they have placed, my lord. Now, my submission, my lord, the second glimpse of my argument, this point is this, my lord. This compilation, if my lord may again take the pain of taking this compilation, that ordinance compilation, my lord, that I have given, my lord.
Yes.
If my lord may kindly come to page 38, my lord. This is an example of the certificate which has been issued to me, my lord.
Yes.
Sri so and so, roll number so and so has passed examination, MSc zoology examination of this university held on so and so. So in MSc, I have passed in zoology department, my lord.
Is not available in petition?
No, my lord. These are just for example I am giving, my lord, because there has not been.
This is the petitioner's qualification.
Is there, my lord? We have given. We have given, my lord. Now, my lord, may kindly see in page 39, my lord. Page 39, my lord.
Yes. Yes.
This, my lord, that PhD in zoology in the School of Life Science.
Yes.
It's different from PhD in life science, my lord. Now, next certificate, my lord, that
But
just
where's his qualification?
who's, my lord?
The respondent number 6, same thing. School of Life Science.
No, my lord. It is the school. It is the school in zoology in life science school, my lord. But it is his PhD is in life science itself, which is the subject itself. It's not in school, my lord. In that school, he has done.
Is it possible to get PhD in life sciences?
Yes, my lord.
It's not so specialized. Life science is very broad, like you said. So then,
my lord, next, my lord, page 40. If my lord may kindly see table 3, my lord. Page 40, my lord.
This mark sheet.
Yes, mark sheet. What
is Kohli Biswas?
Here is one just for an example, my lord. Now, in my lord, we can special paper biochemistry. Specialized. I have been specialized in biochemistry, my lord. This is an example, my lord. Now, my lord, we kindly see the last page. That I have already taken, my lord, to zoology and life science. Zoology. My submission that my lord, respondent number 7 doesn't fulfill the criteria of the advertisement, and he doesn't have the specialization to apply for the post, my lord. And moreover, more interestingly, my lord, if my lord consider that the waiting list is also from chemistry, my lord, where in the first round of litigation, my lord, it was submitted by the Nehu, my lord. On his statement, the entire writ petition was closed, my lord, that only a zoology background candidates will be allowed to participate in the process, my lord, and a cost was imposed upon me, my lord. So I will just simplify, my lord, that respondent number 7, 3 points that I have raised, that he doesn't have specialization as per the
at the master's level.
At a master level,
Yes,
he is not from zoology department.
Yes.
Third point is that his PhD is not from cognate or allied subject matter. Which is contemplated in RA4 of the regulation, my lord. Nehu.
Yes.
Judgments I have already placed, my lord, so I rest my case.
In fact, my lord, these were the submission my learned friend started the writ petition. You see, I took all the pain, my lord. I may be wrong, that's ultimately my lord's desire. I took all the pain to answer all these things, your lordships. So now again, my lord, but the same submissions were made. So if your lordship wants, my lord, I'll have to start again. From the qualification again, my lord, related subjects, I'll have to start from there, my lord. I have no other option.
You just have to refresh the code because...
Yes, I'll have to, because I understand the gaps, my lord. There are too long gaps.
Because I think you had made your return submissions in 26 March, Mr. Chongreso.
No, I understand that. My lord, I'll do that. I'll do that, your lordship.
Same day
Then,
also, sir.
my lord, I'll just start with, my lord, the requirement, my lord. What are the requirements for, my lord, for the post of professor, my lord, the qualification? These are prescribed by the, my lord, UGC. And the one which is holding field and govern the present case, my lord, the UGC regulation of 2018. Now, what it say, my lord, 2018?
Otherwise, Mr. Sen, you give your notes on submissions.
No, I'll just briefly, my lord, few aspects, my lord. I won't take much time. I'll just try to shorten it. Now, my lord, if I can, lordship, if I can take, my lord. So far notes are concerned, my lord, I have already, my lord, submitted a compilation at the time of hearing. If your lordship come to, my lord, page 60 of the UGC regulation. Now, what are the qualification requirements? Professor eligibility. Page 60, my lord, of the UGC regulation.
Yes.
My lord, in the bottom for professor, generally. Eligibility either A or B will suffer.
Yes.
Now, A is an eminent PhD degree in concerned relevant. My lord, you will take note. Concerned allied relevant. Now, my lord, who determined that? I'll satisfy that, your lordship. It's not the academic council, no authority of the university. It is the expert. And expert are, my lord, in the field are part of the selection committee, my lord. There is a lot of difference, my lord, screening committee and selection committee. Selection committee, my lord, they were expert, my lord. And it is for the expert that they have to decide, your lordship, take a call on this. So it's say, my lord, concerned, allied or relevant discipline.
Okay, if you just pointed now to his, regarding whether screening committee,
lordship,
the constitution, which he says the dean has headed it, though the professor from zoology is there, zoology, correct? But then there's no external thing. Will that vitiate the screening process?
No, my lord. I'll come to that, my lord.
That's one part.
Just this part I'll finish. Briefly I'll finish, my lord. The few things
Second part, the only thing which is quote, maybe will have no impact on the case also, is only the fact that whether one candidate can apply separately in two applications for unreserved category and for the OBC or scheduled caste, scheduled tribe category, right?
Yes, my lord. I'll say
because your ordinance envisages provides two selection, like separate interviews, correct, for these candidates. But whether a candidate now should be restricted only to, can he be restricted only to applying to one application under the unreserved category, or whether sorted out at your level only when applications come, if the unreserved categories or if the reserved category candidates are set apart and separate interviews held for them, and the reserve and the unreserved are separate. That's the only thing. What is the practice before? So whether it has such situation arisen where one reserved category candidate has put one application and he's been interviewed twice.
Man, I'll just point out, my lord.
That's the only thing that is quite strange.
Only on these 3 points, my lord. I'll not get into other point. So if we can just finish the first point, my lord. Then I'll second and third I will come.
Professor.
First, my lord, related and all, this is to be determined by the expert, my lord. And my lord, you will take note, your lordship, there is no allegation that there are problem with constitution of the selection committee. Not a whisper. Not they have say alleged, my lord, malafide towards the expert, not the expert or party before your lordships. Had the expert been party, perhaps, my lord, how it is relevant, to what extent it is relevant, they could have explained by filing an affidavit. Now, my lord,
I have not done that. Never challenged screening committee.
No, I have not challenged, but I have brought into record. Please let me finish.
Yes.
We have challenged, my lord. We have brought by way of an additional affidavit. We said, my lord.
Okay. Yes.
Now, my lord, will consider professor and or research experience national level or be, my lord. Now here, my lord, some confusion, but I'll try to clarify this confusion.
Yes.
An outstanding professional,
yes,
having PhD degree in the relevant allied applied again, my lord, relevant applied discipline from any academic institution not included A/industry. Now, two categories of candidates are contemplated here. One, those who come from academic background, and one coming from
background.
industry like
Industrial
IITs and all, your lordships. Then, my lord, supported by documentary evidence, provided she has 10 years experience. Now, lordship will take note, what my learned friend has referred to that Kerala, my lord, I will clarify that. Nowhere it say post-PhD 10 years experience. It's a generally in the academic field you should have experience of 10 years, but requirement that you should have PhD. It do not say, my lord, post-PhD.
Okay.
Now, my lord, if I can take your lordship regarding the criteria in the academic field, my lord, that is page 76. Page 76, my lord. 4, 5, plus 5.
1 second.
In the case, lordship has got
76.
76.
Yes, plus 5.
Yes, plus 5. In the case of selection of faculty members who are from outside academic field, my lord will take note that academic field and are considered under this, there should be criteria laid down by the authority of the university. If they are from outside the academic field. No, here this man is from academic field, not from industrial background. So suppose a person candidate come from an industrial background, then there is a requirement academic council might not lay down the criteria. Here the laying down of criteria will not come.
Yes.
Now, my lord, if I can take my lords to rules 6, your lordship.
Of the OE3?
No, my lord, of the same regulation. It's got 6. IQAC, what? Yes. My lord, rule 6, if your lordship selection procedure, my lord, this is all provided in 2018, which is being followed at page 75. My lord. Selection procedure, my lord. How the selection is to be conducted. Now, my lord, these are the guidelines provided by the UGC. My lord can skip 1, 2, 3, 4, 5. I have taken 2, my lord. 6 also lordship can keep. Lordship will kindly come to 7. Now, 7 speaks about setting up of a internal quality.
The same page that you read just now.
Yes, it's my same page. Will come back. Start from 6. Start from 6. Start from 6. No, why I have taken my lord to 6?
High Court, you took me again round.
No, why I have taken to 6? No, why I have taken to the heading selection procedure.
Right.
It speaks about selection procedure. Then under the selection procedure, this has been laid down. Now your lordship come to 8. Internal quality assurance cell shall be established on all university colleges as per the UGC national assessment such and such, with the vice chancellor chairperson, principal chairperson, and the AQA shall act as a documentation record keeping cell for the institution, including assistance in the development of the assessment criteria, methodology, performance based this regular. AQAC may also introduce, whenever feasible, the student feedback system per NAAC guidelines in the institutional parameters without incorporating the of the student assessment individuality. So, my lord, they have clearly speaks about, my lord, setting up of IQAC and involving them somehow, my lord, where they have not mentioned in the selection procedure. Involvement of IQAC in the selection process. Now, my lord, so far screening committee is concerned, my lord, nothing has been provided, my lord, in the UGC regulation. No, screening committee is the initial administrative initiative, my lord, to screen out.
Yes, you can appoint anybody.
Exactly, my lord. So now, since we have a, my lord, to be fair, we have made a regulation, my lord, ordinance on this. And the ordinance we have provided how it is to be constituted, my lord. Now I will, my lord, come, my lord, to your lordship next queries regarding the constitution of the screening committee. Now, if I can take my lord to OE3. OE3, composition, OE3. Where is selection committee? Composition of selection committee. Is that composition of selection? OE4. My lord, this is sorry, this is OE4, my lord.
Just this OE4. That's the committee. Vice Chancellor. Whatever is recommended by the
All right. Before that, I want. Well, now, my lord, if your lordship can take my lord OE45, OE45, my lord.
It's not here. Given me. Skip it from 3 to 5.
We have given also, my lord. In the first hearing, my lord, we have submitted.
1 second. OE3.
I think with that compilation of my landed friends, second compilation, my lord, it is there.
OE4 is there in my additional affidavit itself. My additional affidavit, my lord, may kindly see in my additional.
You not annexed it in your compilation here.
No, my lord, because I have already brought on affidavit, my lord.
Am I trying to confuse the court or?
No, that is not my intention at all, my lord.
Yes.
My lord. OE45.
You should provide.
OE45. My lord, if I can read it. Administrative scrutiny.
1 second.
My lord.
OE4.
5.
At clause 5.
Lordship.
Procedure of scrutiny.
Yes, ma'am.
Yes.
Now, in the first instance, an academic particular candidates like age, etc., my lord, that's not very relevant. We'll come to the screening of the application. Now, this is the screening committee. An application of all the candidates for the post of assistant professor, associate professor, professor.
Oh, you read it earlier on. That was in the affidavit, yes.
Yeah. Shall be forwarded by the university office to the head of the department concerned, who shall ordinarily, lordship will take, ordinarily, not in all situations, ordinarily be the chairman of the screening committee. However, if the head of the department happens to be an associate professor, the application for the post of professor or equivalent shall be forwarded to the senior-most professor in the department, failing which to the dean of the school.
Yes.
Or the vice chancellor. It can be a my lord head of the department, can be the senior most professor, can be the dean, or can be the vice chancellor. The head of the department.
You mean to say the 3 options?
Options are there.
HOD,
and
dean,
then here is some reason. Yes, my lord. I'll just come to that, my lord. Why not HOD? Why the dean was allowed, your lordships? Because my lord, I could have answered this better way, my lord, had there been pleadings. There is no pleadings at all, my lord. Nothing,
Let's disregard that.
Just affidavit I brought, my lord, they have not given me. They have not supplied me the copy when I have made a request to them. And after the order of this honorable court only, they have given me the academic council result, my lord.
Okay. The head of the department
that Nehu always adopt, my lord.
That's why you wanted to withdraw the matter.
Yes, my lord, and he has objected. Otherwise, I could have pleaded, my lord, properly, and he could have answered. He could have got sufficient time to answer.
Well, if I can, the head of the department shall
advocacy skills.
Yes, that is what we are learning from him, my lord.
So learn from that.
Yes, my lord.
The head of the department shall constitute a committee of not less than 3 teachers in the department, not below the rank of associate professor, including professor in the department or from the department, in case there are not enough faculty members in the department to screen the application for the post of assistant professor, associate professor and equivalent, and for preparing a list of candidates for interview. Now, the second part is very important. This is for professor. Similarly, a committee shall be constituted by the head of the department or the senior most professor or the dean of the school, vice chancellor, as the case may be, for scrutinizing the application for the post of professor or equivalent. It could be either of these three. These committee shall comprise not less than, my lord, 3 teachers, shall include all professors in the department and at least 1 professor from
There's
another
only one. He is only sticking to this one.
Right.
That there's no one from external.
Well, it's very clear and very categorical. One thing, this is initial administrative stage. This is not the selection committee, my lord.
Right.
This is the screening committee. And the screening committee, my lord, we have constituted the committee as per these requirements.
But what are external?
I'll just come to that. Your lord.
See, this committee shall comprise of not less.
Lordship.
And shall include professors and at least 1 professor, not the party.
Lordship.
Yes.
Committee professor who are re-employed. Now, my lord, second, ordinarily the number of candidates recommended for interview for post, lordship can see short list of candidates. And then, my lord, if I can take, my lord, to 7. Where is it? If I can read 7. Application along with the recommendation of the screening committee shall be forwarded by the chairman to the Vice Chancellor for approval. The Vice Chancellor may refer the matter to the committee to review its decision for reason recorded. Yeah, it was referred to, my lord. It has never been sent back for a review. That means it was approved, my lord, by the Vice Chancellor. Now, my lord, if you can take your lordship.
But only that external part. That's not.
No, I'll come. I'll come to it. That's
yes. How do you overcome that?
My lord. 9. Notwithstanding anything above.
Okay.
Any notification in this regard issued by the University Grant Commission, Ministry of Human Resource Development, Government of India, and adopted by the university shall be applicable. In spite of what he is saying, my lord, if there is a requirement need to be followed as per the direction of the UGC, my lord, these will override everything. Now here, as I have pointed out, my lord, UGC regulation, my lord, why I have referred to that heading, that was very important. I have taken my lord back to that 6, selection procedure. And under the selection procedure number 6, my lord, clause 5, my lord, clause 7, my lord, categorically say there is a need for the purpose of selection, IQAC. Now, university had set up a IQAC at that relevant time, my lord. One Mr. Professor Dixit was the director of that IQAC, though he happened to belong to the geology department also. But by virtue of his holding this post, my lord.
So you say that you have taken this other alternative.
Yes,
keeping in mind the recommendation of the of keeping in mind the OE3 clause 6.
Lordship.
That this IQAC necessity of establishing every school and every college and university.
Yes, my lord. And to be involved in the selection process.
So we have involved. So the whole screening committee should not be as per the university regulation then.
My lord.
Should not be. If now you're given a go by.
Lordship.
But also only an exception with this external member that you put in as IQAC.
No, IQAC, my lord.
Substantially, you're complying with your own this. What is this? OE4, right?
Lordship.
But then, with regard to this IQAC, you're coming to this section procedure as given in the UGC regulation.
Lordship. Because these our own ordinance say, my lord.
That's a very twisted kind of submission.
No, my lord. These say, lordship will see notwithstanding.
I'll take to this OE4,
lordship.
clause 9,
lordship,
to bring in this clause 6 of the IQAC, the selection procedure given in
lordship.
The UGC regulations.
Correct. Lordship. Because it provides in that clause 9. Ordinance, my lord, OE 49 provides that. These are all subject to
very convoluted submission.
Very, these are subject to, my lord, any requirement to be laid down by the UGC.
So you've done away with external member in order to bring an IQAC member.
My lord, here, my lord, because now he being a director, my lord, he has come. Now, second thing your lordship will do, this is a screening committee. Now,
but he happens to be from the same department.
They happen to be same department. Same department, he happened to be. Now, by virtue of his office, my lord, he has been treated as an external member and as a director, being a director as per the requirement of UGC. Now, my lord, what happened? Now, the screening committee, whatever recommendation are made to the screening committee, it will go before the selection committee. Okay. After all those formalities, it will go. That matters, my lord, before the selection committee. Now, selection committee, my lord, there is not a whisper against the selection committee. comprised of the experts, my lord, who have the expertise in the field. They made the assessment. So obviously, my lord, even if screening committee, my lord, recommend a person, my lord, who is otherwise not eligible, my lord, that cannot escape the notice of the selection committee.
Yes.
So my humble submission, my lord, there are substantial compliance, my lord, with the, so far the constitution of the screening committee is concerned. Now the other thing coming, my lord, why the dean has changed? Now my lord, dean was he has retired, dean was at that relevant point of time, not only the dean of School of Life Science, but he was the senior most professor of the Department of Zoology. Now considering he was the senior most, your lordship, my lord, he was allowed to chair the meeting. Now, my lord, how that, my lord, vitiate the constitution?
Only the external, that's the only question. Otherwise,
the external, my lord, this is the only explanation. This is subject to the requirement. So, one of the requirement.
Clarity should be such that it casts.
Yes.
It makes the entire section process redundant.
Yes.
Anything. Not that only rarities which will not amount to can be.
Yes.
Yes.
Now, my lord, this is the thing. And my lord, I could have, my lordship. The other thing now comes. Now, this is regarding, my lord, the constitution of the screening committee. It has gone before this. Now, I'm coming to the subject, your lordship, the zoology. Now, I had pointed out, my lord, in my initial submission also, my lord. Now, my learned friend again saying that only from person doing a master's in zoology is eligible. Now, your lordship will look on the records, his own affidavit. He started his career as an assistant professor of bioinformatics. So, this is, my lord, he is fully aware, my lord, that these are allied related subjects, and this is for the expert. But even then, in my short synopsis, my lord, just I have quoted from certain authority what are the, my lord, definition of zoology, my lord, and then bioinformatics, how they are related briefly.
Only that question regarding double application. Only that was the point. Otherwise, other things that I think we have understood.
That is the thing. And now, my lord, that definition also, my lord, and I have, my lord, already, my lord, laid before your lordship those decision, my lord, constitution and that Mysore University case. Now, in the expert domains, my lord, as a layman, my lord, I could not comment more than this. They are related, my lord. Now, my lord, in the expert domain, my lord, court will not enter. Now, that I have already, my lord, that decision. Now, my lord, other thing also on this aspect, my lord, I'll just close on this aspect, on this point, my submission. If I can take, my lord, my learned friend has referred to in his compilation. In his compilation, now he has referred to, my lord, certain ordinance of the university at page, my lord, 29.
In his writ petition.
No, in the second compilation, 27, man. His second compilation.
The spiral bound.
Now he has filed a second compilation, where he has referred to all that OE3 and all.
Okay. Yes.
Page 27.
This allied and cognate subject.
Allied and cognate subject for the purpose of this thing. Lordship will come to clause 16.
Yes. 15.
15, my lord. Zoology. Now, zoology, what are the allied? Cognate allied means, my lord, related. Botany, biochemistry, biotechnology, bioinformatics. No, he's relying on it. It's not me, my lord. I have brought this. He has brought this. So, my understanding, my lord, now there should not be a, my lord, this is a field, my lord.
This is only to do with round number 7, right? This number is biochemistry. Right. He has MSc in.
No, they are either, my lord, bioinformatics or biotechnology. None of them are from biochemistry.
No, with regard to 7 also.
Yes.
He says that 7 has biotech. So biotech is allied to zoology.
Yes.
So his submission that he has only this in MSc and in PhD life science.
Yes.
Doesn't have the basic core. So then.
Well, if your lordship look from 12 onwards, biochemistry again, your lordship see biochemistry is related. Botany, zoology, biotechnology, bioinformatics.
I've even marked it, yes.
My lord, 12 onwards, your lordship, 12 till lordship 15.
And the petitioner does not have what? He does not have any of this. He has bioinformatics.
He is geology. Petitioner, my lord, he is from geology. He said only geology can hold this post, nobody else. But he started his career as bioinformatics, assistant professor bioinformatics in some university.
But
that
is
on
related
record.
to zoology only.
That is on record. So these are related, my lord. I think we should
He's
not...
related to zoology.
Related.
Bioinformatics.
But what is my submission, what my learned senior has not understood for respondent number 7, my lord, is this, the respondent number 7, my lord, life science. He has done his master in life science, my lord. My lord, may kindly see.
He's done masters in biochemistry. Correct?
Just this, my lord.
Yes.
Let me again please his affidavit, my lord. Respondent number 7, affidavit, my lord.
Biotechnology. Biotechnology, my lord, not biochemistry.
Biotechnology in a master degree, my lord. Biotechnology.
Yes.
What is my point is this, my lord? PhD in life science. Whether life science is included here, my lord, allied subject.
No.
Yes, my lord. He has done it.
You are countering your own argument. You said I can have I can do my basics in what? In chemistry.
My lord.
Right.
My lord.
And then I do a PhD in an art subject.
Yes, my lord.
So I can't say that that I don't have doesn't mean that I have a basis on an art subject. Same thing. So now he says zoology is related to biochemistry comes under its cognate subject. He has in biochemistry or bioinformatics. What doesn't mean that he has MSc in life sciences, which is somewhere related. You can't say that he doesn't have the core. I mean the speciality in MSc.
My lord, may kindly see.
Anyway, just let him continue.
Yes, sir. Now, my lord, this is the thing. My lord, I think this is enough, my lord. We will not ally it relevant, my lord. Leave it to the expert, my lord. Expert are not before you. Now, my lord, coming to the other point. Now, my lord, coming to the other point, your lordships.
We'll give it to 1 o'clock.
Yeah, I'll try, my lord.
Mr. Changre, so you want to make a submission?
I'll give a shorter written submission. That will cover. Okay, now when he is unable to.
Mr. Pranobri also, yes.
So, my lord, this belongs to the expert order. They have done it, your lordships. Now, my lord, coming to your lordship, which is in your lordship, my lord, disturbing perhaps, 2 interviews.
That's the only thing.
Yes, my lord, I'll clarify, my lord. In fact, my lord, I tried to clarify in my first submission. Now, because of the gaps, I understand your lordship. But even then, I'll try, your lordship. Now, my lord, what happened?
Not 2 interviews. 2 interviews, yes, but whether 2 applications can be allowed.
Yes, exactly.
That's
exactly. That was answered substantially, not only by me, by the private respondent also, my lord, with reliance to the portal and all. But again, you will try to refresh my lordship. Now, what happened, your lordships? Now, these qualification selection procedures, my lord, these are prescribed by the UGC. University has no hand. University, my lord, is confined to the constitution of screening committee, my lord. That is provided in this. Other thing, it is mandatory, you will have to follow UGC, how the selection committee is to be constituted. Now, my lord, these are time to time revised, my lord, following the pay revision of the teachers. This normally follows the central pay revision. Now, what happened, my lord, till 2010, my learned friend is referring to that Himachal Pradesh. That was a selection, my lord, arising out of 2010 UGC regulation. Now, 2010 UGC regulation, my lord, things were quite normal. Quite normal in the sense, things were, my lord, mostly manual. Not mostly manual, all manual. All manual, your lordships. We had not switched over to online.
To digital, you mean?
Exactly, your lordship. Problem started with
digital.
Switching over to digital mode, your lordship. 2018, this is admittedly under 2018. I think 2014 onwards, my lord, there was a push to go digital. Now, there is a direction from the UGC. There is a common platform and portal. Without platform and portal, my lord, only the online applications were permitted. Only the online applications were permitted, followed by hard copy. And that was mandatory. And if I can take my lord to the advertisements. Advertisement. Advertisement categorically has to be on. My advertisement is at page 33. 16 March 2022. Lordship has got it.
Yes. Which
Online applications are invited from Indian national filling up the post for various posts, etc., etc. So this is, my lord, mandatory. Now before it was not there. Now it's online mode is mandatory, my lord. Now online mode, your lordships, the particular, my lord, portal, there is no provision for, my lord, filing a single applications, my lord, for giving preference for both categories.
For UR and for
there is no
reserve.
provision. There is no provisions.
Okay.
And they say you file mentioning specifically your category. And if you, after filing, if you want to change, they have given a direction how to brought about a change in the category. So in the situation, my lord, most of the candidates who want to participate both in general as well as in the reserve category, they filed separate application and for which separate ID was issued.
Separate interview.
ID means, my lord, what do you call?
Yes.
What is that? That format is here, my lord.
Admit card.
My lord. I think we have given a copy to this.
See, the things that
there is
flooded with papers now.
I mean, all these things were placed before, my lord. Or that portal made it clear, my lord. The application has to be.
Has to come by affidavit? Or
there was a, my lord.
It's in the website.
No, have you placed in the affidavit? Have you said this now? No, it is not there in writ petition also.
No, there is. We have said
that they can't be to application.
We have said in the additional affidavit, my lord, and they have not filed a counter, my lord.
No, that's fine. Yes.
Now, my lord, query number, my lord, 10. How to apply for different category orders? Answer. To apply different category post, a candidate must register, use separate email, my lord, for each category. There is no other option. But things has drastically changed, my lord, after we switched over to online.
So suppose you're a person with disability or economically weaker section, that means you one application. If you come in the reserve category, another application. Suppose there are 3 vacancies, one for UR, one for reserve category, and one for EWS. So now you're putting 3 applications. Suppose you are EWS, you are reserve category, and you're applying for unreserved. Then 3 applications are to be filed.
I can't help my that situation normally should not.
That means you'll go for 3 interviews. The chances of success are more than
normally.
I will know the mindset of the judges.
Normally,
Yes,
it should not come. Normally, this kind of situation should not come. Now, this is one thing, my lord, because of
Suppose
online.
for a civil service exam, right? Can the same digital format? I mean, what do you say?
My lord, here I will try to distinguish one thing.
So that is the thing that it seems incongruous.
No,
in a way,
no.
Because one person, a civil for state civil service, whatever. Suppose they give 3 options, right?
Well,
and then like he clears the mains, whatever. Then he's called for 3 interviews.
well.
As per what this OE allows.
Perhaps I will try to clarify to some extent. Lordships, appointment of teacher in the university, selection involving appointment of is unique, is totally different from other interviews. Why, my lords? There is nothing manually to be done. So for 2010 is concerned, my lord, rules, academic performance. They have standardized the mark. For your publication in this particular journal, recognized journal, this is the marks. Now what happened after my lord computerization? These are generated by computer, not manually done. Only the expert will see, okay, this has been generated by the computer. Now here your lordship will see, respondent number 7, his generated mark is 2015 point something. What is his marks? 637. 600 something. 637, my lord. 637.
Okay, doesn't matter.
And my lord, 2000 something, 15. Now these are all computer not done manually.
Based on academics.
Yes, excellent, lordship. Qualification, publications,
AQI scores and all.
my lord, these are generated by computer, and this is the reason, my lord, why it is like. It is not like MPSC, UPSC exam, my lord. They will see the right long answers. It's not like that. So only they look into the, my lord, academic performance, and expert made the recommendation. So here it is little different, my lord. So this is the reason, my lord. Now, secondly, my lord, I have mentioned in my synopsis also, I have submitted that Pradeep Dahal case. Now, Pradeep Dahal, my lord, it involves a state university. Now, my lord, though they are following the university UGC guidelines, I mean UGC qualifications. Now that's, my lord, following the 2010 UGC regulation. We are not online, and it was slightly different, my lord. But there what happened, my lord, ultimate issue is court had not set aside any selection made pursuant to that. Now there the contentious issue was amongst both reserve category, both way obviously. Now, one of the complaint, my lord, which was before the court, that I appeared, my record was by mistakenly placed before the general category when the selection was conducted for the general category, and some marks was entered in my records. But when I appeared for the interview before the reserve category, no marks was given. That was noticed by the Supreme Court, and Supreme Court reacted. What is the need, my lord? That is absolutely wrong to have two separate interviews. That is with reference to 2010. Okay. Now, by this time, what happened, my lord? 2019.
Only one thing, you see, what looking at the level playing field. Now, the thing is that now, won't it, if the two selection processes, won't the marking system be different? Can it be like, a very objective kind of
no, marking, my lord, as I said, my lord, marking was substantially, my lord, more than 80%, my lord, almost all the marks, my lord, will based on the academic
discussion. Now you have separate selection for reserve candidates, separate selection for general. Then like cutoff you might have for reserve candidates. So like if it's not the same selection committee, then would it be and even the requirement that the recommendations be placed first before the sections carried on the second. I think the system is a bit flawed. Maybe we have to follow it because it's governed by your guidelines or by your statutes or by your rules. But the thing is that, you see.
Yes, my lord, what is in your my lord's mind, and that come very obvious. It will come very obvious if there is a, my lord, selection like MPSC, UPSC, my lord, obviously that will come in a big way. But again, I will say, my lord, university selection, my lord, is altogether different, my lord. These are all based on API marking.
That element of level playing field that you go before same selection, results are equal. You fall in unreserved or reserve. That's whatever you apply for. I mean, you got category you fall in. But the thing is that now to say the fine, now unreserved, now in your separate interview, you score very high. And then when you compare to the open category, you score more. That means all those open category seats will go. Those are the things. That's the only thing.
Yes, my lord. But here, so far, here this, my lord, I am disclosing the mark. 500 something, my lord, so for the reserve category. 500 something in. So he is out. He is out from general. So for reserve category, my lord, he was number 1 with 537.
Yes.
And the others, my lord, I have already stated them. So this another thing happened, my lord. In the meantime, central, what is that? Central Educational Institution Reservation of Teacher Cadre Act 2019 in the meantime came into force. Now, my lord, before it was university-wise reservation, now it is post-based reservation. And post-based reservation, my lord.
You take it back. Okay.
My lord.
Yes, yes.
Now 3 of that act say, notwithstanding anything in any other law for time being holds, there shall be reservation of posts in direct recruitment out of the sanctioned transfer in the central institution to the extent and the manner which may be specified by the sir. So, my lord, we have switched over to post-based reservation.
Yes.
Post-based reservations, my lord. So all this makes now their way direction, my lord. We have to be very stringent, my lord. When it comes to the reserve category, my lords, we'll have to take due care, my lord, that the posts are filled up only by those candidates, my lord, who belong to that category. So it became more stringent on us. So, my lord, now, my lord.
Yes.
So far, my lord, that Pradeep Dahal's case, my lord, as I said, my lord, these will have not an application, my lord. This is more of a obiter, my lord, than a ratio. It has not laid down as such. UGC was not. To take a decision call on this thing, my lord, we need to hear UGC, my lord. Then whether it should be. But these are at the direction, my lord. I think once 2006, even UGC said we hold them separately.
Yes.
I have supplied to my lord. Even the UGC said. There the UGC was not even a party. So that at best will be a obiter in that case, not a ratio. It could not have been laid down a ratio, my lord. And there, my lord, the appointments already made were not touched. Now, my lord, coming to my lord, if your lordship wants, my lord, that single bench judgment of Kerala High Court, that is actually not a correct judgment. That has been subsequently Delhi and Madras. Delhi and Madras said, if an additional qualification is not prefixed by post, like here, my lord, PhD, they have not mentioned post PhD, then something, my lord, which is not there should not be read into an advertisement. Here it is not saying, my lord, post PhD. Even if your lordship wants, my lord, those are the two judges. Huh?
No, see, post PhD
lordship
will come to, there are requirements in the advertisement itself or the criteria.
Lordship.
Suppose a principal post, say you're associate professor having, so this kind of thing.
Yes. No, here it's not mentioning post PhD.
No, looking into yours, that E and B, correct?
Yes.
That, where is that?
6.
No, from that
regulation.
From the regulation, yes. Anyway, anything else?
So, my lord, if your lordship can
close it today.
Yes, my lord, yes, your lordship close it. My lord, I am referring to, my lord, two judgment on this point has been clarified by Delhi High Court. One is, my lord, 2020. I have given you 2020 SSC online 3114.
3114.
My lord, lordship will get the relevant paragraph at 3.7, 3.7.
Yeah.
25, 26, 27 and 30. Similar issue, my lord.
Yes.
And then one more, my lord, 2011 SSC online 294, 1494.
1494.
Yes.
Paragraph?
2011 SSC. That is a Madras, my lord.
In paragraphs?
Paragraph 19 and 20.
What is SC online Madras? Yes. You say that, no, Madras. And on Delhi.
Sorry, my lord. One is Delhi, one is Madras.
Yes. Then, first on Delhi, yes. Okay. Paras?
So far, my lord, Madras is concerned, paragraph 19 and 20.
Okay.
So, exactly the same issues. Unless post is mentioned, the word post is prefixing the higher qualification, then that should not be read into. And even in the Kerala High Court judgment, your lordship, these are passed as a mere observation. In the concluding paragraph, learned single judge of Kerala High Court has held that if he applies afresh, if he is otherwise eligible, the observation made should not influence the selection committee. And there his case was rejected by the screening committee, saying that he lacks sufficient academic qualification. So, my lord, that has not laid down any ratio, my lord, and this will have no application here. What else? And my lord, regarding, my lord, my initial preliminary objection, my lord, to crossing the threshold, I have submitted all those, my lord. Idris Ali.
Just give your note again on the a small digest on the decisions relying upon and your points. Yes.
Anything?
Right.
No.
I will submit the written submission. Only point out my page number 47 of the petition. The score of the research and score by the petitioner in mind. I just want to show that. Yes. Page number 47.
Yes.
My lord, at the bottom, research score earned as per the UGC guidelines. Page number 47.
Yes.
My lord, he scored 537.
637.
637.
Yes.
Whereas in my case, my lord, may come to my affidavit, page number 59.
And R6, you score how much?
My lord. In my case, my lord, 582. At the bottom.
How much?
582 in the OPC category. And my friend emphasized the second interview regarding unreserved post. My lord, with regard to that, my lord, can see
my affidavit. My affidavit.
Lord,
You score how much?
my Lord, in the unreserved post also page 76, page number 76, the same, my Lord, 582.
Okay, so
Now since, my Lord, and with regard to, my Lord, the private respondent number 7,
yes,
my Lord, his affidavit page number 9,
yes,
respondent number 7 scored 2001, 2050.
2015.
Yes. So based on this score, my Lord, selected.
Lord, what we're trying to say here is, my Lord, now the selection is based on the score, my Lord, irrespective of there's separate interview, my Lord. So in his category, he was the highest, so he got through, my Lord. He was appointed. In my category, unreserved, I am the highest, so I got through, my Lord. Irrespective of...
You'll give the notes on submission?
Yes.
We'll fix it after 1 week for note submission.
I will prepare.
Yes, here, arguments are concluded. Parties submit their notes on submission
within a period of 1 week.
Within 1 week. List of yes. I didn't want to pronounce matter anymore because adjourn unnecessarily.
$135. $135.
Mr. Deb is on leg, Your Lordship. Kindly call this matter at the end of the board, Your Lordship.
Mr. Deb on leg?
Yes.
There's an application of adjournment by where's the SKH no room? I received a copy
Item
of the
142 also, Your Lordship. Mr. Deb is on leg.
135.
We'll adjourn it for 1 week only. This one. Yes, 120. 125. Only for 1 week. They file application. Allowed for reasons stated therein. Yes, after 1 week. Yes. This is one I want to close the election matters also. Yes. And the other matter?
138.
38, my Lord, I have taken the instruction, my Lord. That principal matter.
Yes.
You may please, Your Lordship.
Ready with the matter?
Your Lordship, I'm ready with the matter.
Yes. You're ready with the matter also? Yes, Mr. Day.
My Lord, I have received the instruction, my Lord. We have filed our affidavit. In the affidavit, we have categorically stated, my Lord, that this is not a technical post. Here, they are
then the persons occupying now the technical post.
No, it is not a technical post.
Who's occupying the post before that?
It is as per the. It is not in the nature. They cannot come and say before this honourable court, my Lord. It is in the nature of. Here, it is only to, my Lord, to see, oversee that the plumber are going, the pipes are fitted and all, to oversee, my Lord, to for example, my Lord, to allot the work.
Now, what is the specialization?
It's nothing, my Lord. Nothing, my Lord.
Qualification. But irrespective of that, Your Lordship, I'm here by way of this writ petition challenging the process of promotion, Your Lordship. The manner has been carried out.
Earlier, my Lord, they said it is a very technical post.
That is one of the aspects only, Your Lordship. But overall, it's on the manner and the conduct in the way the promotion has been conducted, Your Lordship. That is not. That is just a small aspect of the entire issue that I'm before, Your Lordship.
You don't have any rules.
No, my Lord, we have already framed the rules and we have forwarded to the government.
What are your exact instructions?
No, on this part, on the last occasion, when they have...
Yes.
This matter has never been heard at all, Your
No, my
Lordship.
Lord, what was submitted while the matter was initially placed before this honourable court, my Lord, in page 8, we have categorically stated in my affidavit, my Lord. Para 23, page 8 of my affidavit.
See, the thing is that we don't, what is happening, you can't have a person from office now going and standing and repairing pipes, you see.
No, it is not a technical post.
Suddenly going and, a wrench and instead of a pen and paper.
No, my Lord. It is not correct what they have projected.
What is this, page 22?
Page 8, my Lord. Page 8, para 23, my Lord.
Okay,
of my affidavit.
Yeah, 3 and 4.
Para 23, my Lord. Second
page
8 of my affidavit, my Lord.
Yes. Regarding nature of job.
Yes, my Lord. Furthermore, regarding the nature of the job, the duty of the water works superintendent or water work inspector are
That
not
is what
technical
we
in
want
nature.
to know. What exactly the duties of a water works superintendent?
Now, I have stated, my lord, the role of the water works supplier and water work inspector do not involve technical aspect of the water supply system, which are instead managed by the engineer wings of the board. What they are trying to project, it is a technical work, and how can we can ask a lady to go and do it, repairing and all this?
No, Your Lordship.
That is
That's
not
only
a-
one aspect, Your Lordship. That is entirely
Well, here
not
is then-
correct, Your
My
Lordship.
lord, after 2 weeks.
After 2 weeks?
Or
Your
next
Lordship,
week?
1 week, Your Lordship. Because time and again, time has
Next
been sought
week,
in this
wait.
matter.
I'm not
After
playing
1
today,
week.
my lord. We are
Yes. We have other engagements.
My lord.
139.
Highly obliged, Your Lordship.
But because we have that XC versus visiting, that is why.
Item is going on, item 12 is going on, my lord.
Yes, Mr. Vijay Kharsar. When?
After a week, my lord.
After a week, yes. Due to absence of arguing counsel, we have the petitioner just after 1 week.
140.
Alright.
This is not my matter, my lord. It will take time, my lord.
Private respondents?
Actually, this what happened actually, the private respondent here, the petitioner here and filed an application to cancel the registration of Nokmasip. Then after it was dismissed, saying that there was a delay. After we filed an appeal was dismissed, affirming the order of the EM. Then we filed before the approach before this court have directed to file a separate application for condition of delay, that there was only 35 days delay. And then on the basis of the compliance with the order of this honorable court, we filed an application, separate application, and also the appeal. Now our continuation of delay was allowed, and we are allowed to file the appeal. We filed an appeal. Appeal was decided. The appeal on the appeal, they have not decided the merit of the case. They were only saying that the order what they have earlier order passed by the EM was just upon without discussing.
When was the first order passed?
No, His Lordship, I will just take you the.
When was it passed?
Yes, the impugn order, my lord, that is the page 56, the final order. May I just take you? It is very short actually. I'm not on merit, but only the procedure on the procedure. So the operative part of the order, my lord, it is page 7 and 8, my lord, just I'll say. So it's a very short issue, Lordship, I'll just say. Page 56, it started from page 56. Yeah. So it's a type copy. May I read the para 8 and then 12. As for the case record, the appellant were one on
Mr. D.
My lord.
They didn't go into the merits at all of the appeal.
They have not gone. It's because, my lord, may kindly see in page 57, my lord.
Yes.
As per the record, the appellant was warned on 21st/6/2018, giving last chance.
Yes.
The appellant again applied for adjournment on so and so date. It can also be seen before the date of impugn order. The appellant failed to take steps on so and so date, so and so. No one appeared, my lord. No. What can we do, my lord?
Your Lordship, just see the.
For this, my lord, we need to examine the record.
That order already been discussed in the page 45. The High Court has already given a direction. Page 45, relevant para, my lord. Yes, page 45. Because my continuation
No. Your continuation before the chief executive member, correct?
Yes, chief executive
member
member
has been allowed, and he's considered it.
Yes,
He's seen that from the audit sheet of the executive member that you were very
No.
You're not pursuing the matter in a proper manner.
No, Your Lordship.
That's why he said that you.
No, they are supposed to decide on merit of the case.
Or even if in your absence, then he will come and say.
No, Your Lordship, kindly see the page 28. That is the basic foundation where the initial order passed by the EM. This order I have challenged.
Yes, he's considered the dismissal of your case for executive member was what? On default, right?
Yes, my lord.
It was for default.
Yes.
Yes or no?
Yes.
Yes or no? Right, okay, hold it there. Now, against the dismissal of default, you went and filed a appeal before the CEM, which was not allowed because of you didn't file a condemnation application. Correct. Now, because you did not explain the delay in preferring the appeal, you came for this court.
Yes.
Those courts are fine. You go back, the CEM will consider the condemnation application, decide the matter on merits.
Yes.
Okay. Merits mean merits of challenging that case of default. Now he has come, now it went back to CEM. CM saw that no, from the records that your conduct does not, warrant that he should be given opportunity. So he's not interfered with the discretional, exercise discrete power by the EM and has upheld the order. That's all. So he's heard it.
The order, the delay also only 35 days.
No, he's heard it. He's condoned the delay and heard your matter. And the merit of the matter is only that it was dismissed for default by the EM. He didn't challenge any other things. So.
No, they're supposed to merit, they're supposed to decide only on merit.
Don't make a kind of submission. Let's go to the early order of this court. See, come to page 44, each para 6. Read it.
From the record, it appeared that the order dated 24/10/2008, the EM, the Iceland Revenue Judge Tura, has dismissed the petition on the ground that the petitioner had not taken the required step.
Yes.
And that matter was lying pending for numerous days. Also, pursued the impugn order wherein the CEM, after consideration, had observed that the appeal was barred by the section 8(2) of Garo Hills Autonomous District Council Social Custom and Usages Act, Balloting Act 1958, and that no sufficient ground had been shown for the said delay. Now 7. By the petitioner's submission, it is submitted that there is delay of 95 days. However, on examination, it appeared that the same is incorrect, in as much a copy of the order dated 24/10/2018 had been obtained on 09/01/2019, and that appeal had been prepared on 28/01/2019, and on a rough calculation, taking into account the 60 days as allowed by statutory appeal, the delay would be 35 days. However, this fact was not adequately presented before the CEM, nor was an independent application prepared stating the specific reason for the delay. Taking into account the entirety of the circumstances, the fact that the petitioner has only put forward the limited prayer for reconsideration of the delay by the learned CEM, this court deemed it fit to partially allow the prayer of the petitioner with the following direction. The petitioner is permitted to file a specific application for the continuance of delay after computing the exact number of days delay and to offer explanation for the same. The CEM JGDC Tura, on receipt of the application to reconsider the matter and to pass a requisite order thereon, the petitioner shall file the said application within a period of 4 weeks from the date of this order. It is made clear that amidst of the consideration will be strictly on the condemnation application and as to whether appeal should be arbitrated for consideration. With the above noted direction, the petitioners allow the
so what does CM do? After you went, he condoned the delay and found that the reasons given by the EM were fine. You never bothered to pursue the case, so he dismissed your case, finished your appeal.
No, you on that.
Where merits? What merits are you talking about?
That merit whether that.
So shall dismiss it today or leave it for tomorrow?
Next time I will argue my lordship.
Yes, on the Mr. December, just after 1 week.
After 2 weeks, my lord.
142.
142 matter, my lord. The government was supposed to produce the record. They have already done, my lord. Where, my lord? My brother.
I think you have to send for forensic.
My lord.
No, your brother, this is thing, your signature matches the, where's Mr. SD present on behalf of the petitioner appears on behalf of the common advocates? behalf of the state respondents just after 1 week. Please.
Supplementary 1, item number 1.
My lord, the NEPCO policy, my lord, can you see page number?
Yes.
Page number 13.
My lord, like
NEPCO policy. Page number 13.
Page number?
13, my lord. Annexure 1 is a NEPCO policy. Transfer policy, my lord.
Yes.
And page number 18, my lord, we come to page number 18. And 11.7, my lord, we can see.
Yes.
Employees due for superannuation within a period of 2 years shall normally be considered for posting at locations of their choice or nearest to their hometown. My lord, petitioner is, my lord, serving here. Now, he has been, my lord, transferred, even the, my lord, page number 20.
How long he served in Shillong?
My lord, he is serving for quite some time, from 1997. My lord. He was transferred from Assam. He came from Assam. Page number 20.
What is he serving as?
Assistant Manager Finance, my lord, in NEPCO. Page number 20, my lord, 17. He has filed the representation also. They not yet disposed of. And what happened? Impugned order, page number 23.
You have a copy of the petition?
Yeah, we have served him in the morning.
My lord, like 3 hours back, I received the copies. I have not received any instructions also. And in addition to this, like we are also not continuing as a standing counsel of the NEPCO. What I will
not continuing any further.
Yes, your lordship. So I need to take instructions from the concerned department as well as my senior counsel.
Yes, yes. Where is that?
My lord, page number 23. My lord, further, the following employees are transferred and posted as follow, my lord. 1, my lord, Sri Petitioner Ms. Rob Mai, he is the Petitioner, my lord, Assistant Manager, presently posted at such headquarters, Shillong, is hereby transferred and posted to Corporate Account Wing, Guwahati, with immediate effect. With immediate effect, my lord.
Has he been released?
Now, it says, my lord, if lordship can come page number 24, they did not issue any release order, but the above mentioned employees, except such and such, will be released within 10 days from their present place or office of posting to enable them to join in the newly placed.
Where is this?
Page number 24.
In case employees within 10 days, salary will be stopped.
My lord.
Yes.
They did not issue any release order till date. Now, he was asked by the officer to meet the Director of Finance in Guwahati. So, day before yesterday, he went and requested them also. But they insisted for his joining. My lord. Representation is, my lord, page number 25. His detailed representation he has made.
When was this given?
My lord, he has given on 16, and department has received on 17/6. Until there is no disposal. My lord, similar case, my lord, earlier also.
He is 59 years old.
My lord, and he is
and he's saying he's suffering from old age.
My lord, and mainly, my lord, his wife is undergoing a serious surgery.
No, he's saying
yes, also
saying that I'm suffering from old age ailment. Then he should take VRS.
Man, that is the main thing is at the later part, my lord. Number 3, he is Mrs. ailing one, my lord. But just please, the similar case, my lord has passed.
He got a appendix operation. That's all.
Earlier, my lord, we can see the early order. My lord was gracious enough to pass the order.
Oh, yes.
But similar order, my lord has given some protection at that point of time. But number 2,
There's
my
a
lord.
very detailed order I passed with regard to 3 employees taking this transfer policy into consideration. You've seen the judgment, right?
My lord. And even this case also, lordship disposed of, allow me to file a representation. They file representation and they consider representation. Before the lordship has given that this protection. But similar, my lord, I pray lordship may give us some protection. Let the NEPCO, my lord, file a reply. It's a clear violation of their policy.
Take down. Mr. Goenka, you can't accept notice, that means.
Yes, lordship.
So,
I'll seek proper instruction.
No, because you're not a standing counsel also.
Yes, lordship.
Yes. And Mr. General's on sanction leave.
Yes.
We record that, yes. Take down. The petitioner. by the instant petition has assailed the transfer order dated 11 June 2026 as far relates to him, whereby he has been transferred from Shillong and posted to the corporate account wing NIPCO Guwahati with immediate effect until further orders. Next parameter. H.L. Sangreso, Learned Counsel, Senior Counsel, which was on behalf of the petitioner, has submitted that the writ petitioner has how many years of service?
But only 14 months to live. Only 14 months.
14 months.
14 months.
Is at the fag end of his service, and in fact has only 14 months before he retires. In this context, Learned Senior Counsel has referred to the transfer policy of the respondent NIPCO, wherein he submits at para what?
Para 11.7.
At para 11.7 thereof. That employees due for superannuation within a period of 2 years shall normally be considered for posting at locations of their choice or nearest to their hometown. Further, the Senior Counsel has also submitted that where the representation?
Well, page number 25, representation dated 16.
No, where in the transfer policy.
Well.
Further, the Senior Counsel has also submitted that
Paragraph 17.
Clause 17 of the said policy also allows representations to be made against a transfer through proper channel by the affected employee within 30 days of receipt of transfer order. He submits that the writ petitioner has also preferred a representation on 11/6/2026 against the impugned transfer order, which is yet to be addressed by the respondent.
Well, representation date 16 June.
Or 16 June. He therefore prays for limited protection that the transfer order be not ordered to move until he for instance that until the representation is settled, the impugned transfer order will not given effect to. Mr. S. Goenka, who is present, Mr. S. Goenka, the junior colleague of or a junior of Mr. V.K. Jindal, who is a normal standing counsel, is present in court and submits that he is not authorized to represent the respondent at this stage, as he is not the impaneled advocate and has put in an appearance due to the fact that Mr. V.K. Jindal Senior Advocate is on sanction, is on leave.
Yes.
He, however, prays that, notwithstanding the situation, may be permitted to obtain, he will be allowed to obtain instructions from the respondents. Next paragraph. The submissions of the counsels are noted. The transfer policy of NIPCO though in nature of guidelines, however, has put in place the general conditions governing transfers, and the same has been enforced since 8/05/2017, as submitted by the Learned Senior Counsel, and from the materials on record, it is noted that the petitioner is aged 59 years. The retired 60 years, right?
Yes.
And 59 years, which will surely put him at the fag end of his career, and should have fallen for consideration under clause 11.7 of the policy, and further that representation as allowed by 11 by clause 17 has also been preferred. So, in his view of the matter, on the limited prayer, it is directed that till the representation of the petitioner is disposed of, the impugned transfer order shall not be given effect to. Just after 1 week.
Yes,
for
much
instructions.
Yes.
Before the order. Yes.